Item for delivery of order. Item number 47, bail application 2144 of 2024.
Petition dismissed.
Good name is item number 43, my lord. But this is actual matter of 17, my lord. One party or other, my lord, they are getting stayed. I pray, my lord, the other side also agree, my lord, that on 19 it may come up for admission.
Which matter?
Item 43.
43, my lord.
43.
43. I wanted earlier, but they have some difficulty. So 19th, my lord, it may come up for admission. So that it can be disposed of.
43.
Yes.
Interim order may be continued, my lord.
Yes.
Interim order.
When do we list that?
19th of September. 19.
Okay. On the pair, as agreed by learned advocates of both the parties, we shall list the matter on 19th.
For admission.
Okay.
For admission.
Oh, admission. Till then, interim order passed earlier shall continue.
Till then.
May I please, your lordship? In item number 51, I have filed an affidavit in reply, lordship. May I call for pray for
Yes.
call this?
Yes.
Item number 16, my lord. I am appealing for S1 of 5, my lord. I have 2 weeks time, my lord, to file objection to the petition.
Respondent number 6.
6. I have
Item number?
taken 16, my lord.
I am for the petition.
I have also taken permission from
I
the
am for the
petition.
petition.
Acha. Mr. T.J. Soikia, learned counsel for the respondent number 6. 6 with consent from the other side, press for listing the matter after 2 weeks. So as to enable him to file affidavit in objection.
Objection.
Here allowed. Rest is the matter after 2 weeks.
Obliged.
Yes.
May it please the lordship. I beg to mention an item for listing RFA
When?
for orders lordship.
When?
Next week, lordship.
Next week.
For
On 20 September.
20 September. Obliged.
May it please your lordship. My lord, this transfer petition is pending since my lord 2022, my lord. It may be listed for admission on next Friday, my lord. I am for the respondent, entire proceeding is state, my lord.
Next Friday.
My lord, 13th.
13.
Okay.
May I please your lordship? I beg to mention for listing of a matrimonial appeal lordship
When?
on Monday lordship.
Next Monday. Possible?
Okay.
Arjun, little Arjun says.
Okay. Okay.
9.
Deep rooted.
I beg to mention item number 9, my. Is it defect, my lord? My lord. And I have an instruction to withdraw this. Till liberty to file it.
When to be listed?
Withdrawal.
Oh, withdrawal. Acha.
Filing.
Mr. S. Islam,
Yes, my.
learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. Here is accordingly allowed. This CRP-IO stands disposal on withdrawal.
Liberty to file application.
However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
I beg to mention for listing of a CRP on Monday on the urgent basis. As because your lordship, a
Monday,
miscase was
Monday
filed.
may not be possible.
On Wednesday, 11th. On 11th September.
Very urgent, your lordship. A
Maybe.
miscase was filed on a false footing.
Several urgent matters are already listed on Monday.
But police
Wednesday.
implementation has
Wednesday.
been directed, your lordship. On
Pardon?
the false footing, the miscase was filed and no notice was served to us on the very first day without
Alright,
serving.
we will hear you on Wednesday. Any other matter? Any other mention?
Please the lordship. With the consent of the other side, I beg to mention item number 41, lordship. Finally, the matter may pass over for the day.
Lordship, I am from the respondent. 41 item. Date may be fixed.
As agreed by learned advocates of both the parties, let's list the matter on when? After?
On 24th October.
Obliged.
May it please your lordship. With the consent of the other side, I beg to mention item 14, my lord.
1-4.
1-4, my lord. This matter may kindly be taken up after vacation, my lord.
Your good name?
P. Bora on behalf of Mr. A.K. Bora.
On behalf of
Mr. A.K. Bhuyan for the respondent.
Ms. So-and-so, learned counsel appearing on behalf of Mr. A.K. Bhuyan. Learned conducting counsel for the respondent with consent from the other side, first for listening the matter after vacation.
I'm obvious.
Please, I'm paying for listing of RSA.
When
Can you did next?
taken that from
25th September.
Hello.
Items from daily list. Promotion bail application, item number 1.
May, it's a question. Let the regular.
Mr. Roman, I will not take up this matter. List before another bench without me.
Item number 2.
Yes, ma'am. May please also. Because this is the third round of the application matter. Because of certain subsequent development matter, because the petitioner's number 1, daughter, minor daughter, though she was operated just before the arrest of his father, but now because of certain post-operative complications, matter now because the sole breadwinner father is now in custody in this and also because now they are facing a lot of trouble, matter with the family. And
Okay,
because
it is
the-
volume. When he was arrested? When the accused were arrested?
it was arrested, my lord, on 5/3/23, my lord.
23.
23, my lord.
At what stage the case is pending now?
Cases now pending before the Karbi Anglong, my lord.
That's all right. At what stage it is pending?
My lord, because the direction here has been given by the honorable court for a speedy trial, but actually the trial is not yet completed, my lord. At the same time, my lord, now
Whether charge has been framed?
charges has been, my lord, because charge sheet might have been framed, but the things the lordship, we have not communicated, my lord, with the problem, my lord. Family members, my lord.
This case, earlier rejection order is.
Yes, rejection,
635,
2 times already rejected.
Wildlife matter, Dixit Gogoi appeared earlier. I have informed him, actually wildlife matter.
Yes, my lord, while I met her,
Dixit Gogoi was there.
and because of the situation in Manipur now, my lord also knows that better regarding the, ethnic violence, my lord. So many things, my lord, that is why also even family members, they are scattering here and there, my lord, when staying in the, relief camps, my lord, because they are family members.
Okay, we will call for the scan copy of the record along with up-to-date status report. Third, Mr. Your good name, please.
N. Jotendra Singh, NG Singh.
Learned counsel for the accused. And Mr.
Actually, D. Gogoi.
K.K. Parasar, learned additional PP for the state respondent. This application under section 483 of BNSS 2023 is preferred by 2 accused persons, namely N. Mete and Mohammad Waris, who are languishing in jail in connection with Special Wildlife Case number 02 of 2023, arising out of offense report number CR 08 of 2022-23. Under section 44, 48A, 49, 49B, and 50. Punishable under section 51 of the Wildlife Protection Act 1972. Since 5/3/2023. Having heard the submission of learned advocates about the parties, it is provided that recessal call for up-to-date status report along with the scanned copy of the record, fixing the matter
On 23rd September,
short date
Obliged, ma'am.
on 18th September.
18th.
Obliged, ma'am.
Item number 3.
LCR may be called.
Third, Mr. S.R. Sobri, learned counsel for the accused, and Mr. Parasar, learned additional PP for the state respondent. This application under section 483 of the
Sorry, my lord.
BNSS.
BNSS, it is written here. This will be BNSS, ma'am. 483 BNSS.
But what you have mentioned here,
This is.
Referred by accused Mukesh Jadhav, who has been languishing in jail hazard in connection with his
Page number 12. Conduct proceeding may be stayed.
until returnable date. further proceeding of DS number 24/2024 pending before the Court of Learned Additional Districts as FDC, Developer, stands is taken.
Item number 5,
May please, your lordship. Lordship, in this case, lordship, the petitioners, they are the claimants in the original case, lordship. And they instituted the case in the year 2013, lordship, and then award was passed, lordship. That award was 10 lakh something, lordship. And that was challenged before this.
You see, the judgment and award
Yes,
has been set aside by this court.
yes,
So there is no order now.
But-
So how the amount can be released in your favor?
no, that award, after that matter was remanded, lordship, the tribunal took cognizance of the matter, lordship. And even the tribunal was aware that the matter, the judgment has been set aside, but insurance has deposited that amount and subject to our
No,
petition,
maybe
our petition, we file a petition. before the
insurance
tribunal.
company has deposited the amount on the basis of judgment and
Earlier
award
judgment.
passed by the
Earlier,
MACT. And that judgment and award was set aside by this court and
Yes.
matter was remanded.
yes,
Now on what basis the MACT can release the amount in
we
your
have
favor?
already released, lordship.
Where is the order?
Yes,
No, that order is here, but where is the justification?
justification, lordship. Now, the tribunal
How
is
the,
saying
you
that
saw, you saw
tribunal
how
has
the,
released
how
the,
the impugned order suffers from any illegality or infirmity, you saw this court,
yes, lordship,
how?
because
Because there is no order now for payment of compensation to you.
that is their lordship,
Hmm.
but after the matter was remanded, lordship, we have not misled the court. We have filed a petition that could have been rejected. Now, we have already.
No, rightly or wrongly, that was released,
the
but
court is
now it
saying
has
that
been put
it
on
was an
hold.
inadvertent mistake on the
Mhm.
part of the court.
Hmm.
So now, my lord, that account has been kept on hold.
Hmm.
This lady, lordship,
Mm.
is claimant number 1. She is 76 years
You
old.
go and approach the member MACT
We have
and
already
you
approached.
adduce evidence as early
No,
as
already
possible.
finished, lordship. Evidence is finished. It is at the argument stage. The
Then-
member
then,
is saying that at the time of writing the judgment, it came to his notice that the award has been withdrawn.
Hmm.
Yes, lordship will see. I have annexed that order also, lordship.
No, I have gone through the order. There is no infirmity or illegality. Because
No, lordship may
the
come to just page 67.
award, judgment and award has been set aside.
Yes, lordship may just come to page 67. lordship.
No. No merit in this petition.
Or lordship may can just direct the, because already he is lingering the matter, lordship. Let him pass the
Who has
judgment.
been lingering?
That tribunal, lordship.
How?
Because my account has been already put on hold, lordship, by the bank, and bank has already complied with that order,
No,
lordship.
not your account, only that amount.
No, entire account,
Where it is mentioned.
but the bank has frozen the entire account.
You go and approach the bank.
Because the already argument was
Only
heard.
the amount was put on hold
Lordship will see.
as per direction of the tribunal.
Yes,
You see the order?
yes, lordship. The claimant has furnished the.
Your account has not been freezed.
Until further order of this tribunal, the bank authority shall keep on hold amount of so and so. And if amount lying in such account falls short of the amount, the entire amount lying
So
in the
the
account.
argument is concluded there.
Yes,
This is fixed for judgment.
yes, lordship. So judgment can be passed.
Yes, it can
That-
be passed.
that
There is
will-
no bar.
Yes, but instead of lingering now, since my account has already been put on hold, lordship.
No, you're not your account was put on hold. Only the amount was put on hold.
No, lordship will say the second part. If the amount lying in such account falls short of the said amount, the entire amount lying in the account shall be kept on hold. Page 76. lordship.
No, it does not mean that your account has been freezed.
That
Hmm.
entire amount is kept on hold.
When the case was reserved for judgment,
No, it is again fixed for argument, Lordship.
again,
Yes.
when?
Please. 11th of this. After that, argument will be had and judgment will be pronounced, Lordship. That much.
No direction is required. The court will pronounce the judgment
That
within
will be
1
observed,
month.
Lordship, instead of lingering the matter, because account will be kept on hold. And this lady
No,
is
no, no,
76
no.
years old, Lordship. She has been suffering, Lordship. From many
Heard,
old
heard,
age
heard, Mr. Your good name,
M. Ahmed, Lordship.
learned counsel for the petitioner.
Only that observation may be made, Lordship. After hearing the argument, judgment may be passed.
In this petition under section 115 of the CPC, the petitioner has challenged the correctness or otherwise of the order dated 21/8/2024 passed by the learned member, motor accident claim tribunal, Kasar Silsor in MSC case number 51 of 2013. Is to be noted here that white impugn order dated 21/8/2024, the learned member MSCT Kasar Silsor has directed the State Bank of India, Authority of State Bank of India, New Silsor branch to keep on hold an amount of rupees 13,29,752 lying in the SBI account of the petitioner number 1 bearing issue number 103905938850. The learned counsel for the petitioner submits that the petitioner has filed MSC case number 51 of 2013 before the Motor Accident Claim Tribunal, seeking compensation on account of death of their son, struck brother, in a road accident that took place on 2/12/2012. In the said case, learned tribunal has awarded compensation amounting rupees 10,24,291 rupees with 9% interest on the awarded amount for the date of filing of the claim petition till realization of the entire amount. Thereafter, the petitioner, being aggrieved, file an appeal before this court, being MSC appeal number 439 of 2019. And in this court, by judgment and order dated 28/3/2024 was pleased to dispose of the said MSC appeal by setting aside the impugn award and remanded the matter back to the tribunal to consider the same if faced by affording opportunities to the petitioner to adduce additional evidence with regard to the income of the deceased. Thereafter, the petitioner has filed one petition before the learned tribunal, and pursuant to the said petition, the learned tribunal has released a sum of rupees 13,29,752 by the order dated 7/5/2024 in favor of the petitioner number 1. Thereafter, the petitioner has adduced their evidence and also examine the employer of the deceased as PW2. Thereafter, arguments were advanced by both the parties. And while the case was fixed for judgment, the learned tribunal passed the impugned order dated 21/8/2024, whereby the Bank Authority of the State Bank of India New Silver branch was directed to keep on hold the amount of rupees 13,29,752 or any amount lying in the SBI account of the petitioner number 1, bearing AC number 10390593850, on the ground that the said amount was allowed to be withdrawn due to inadvertent mistake. And thereafter, the bank authority has freezed the account of the petitioner number 1, causing inconvenience to her. Mr. So learned counsel for the petitioner submits that the learned tribunal has already heard the argument after adducing evidence by the petitioner and fixed the case for judgment. And suddenly, it has come to the notice of the court, notice of the tribunal, that the amount was released inadvertently as the earlier award has been set aside by this court. And that on account of putting on hold the amount and also the other amount pending, other amount lying in the said account, the petitioner is suffering. The petitioner is facing inconvenience and therefore it is contented to allow the petition. Having heard the submission of learned counsel for the petitioner and also considering the facts and circumstances on the record and the impugned order passed by the learned tribunal, I find no infirmity or illegality in the said order, as the impugned judgment and award dated so has already been set aside by this court. There is no point for releasing the amount deposited by the respondent opposite party before the tribunal. In view of above, this court find no merit in this petition and accordingly the same instance dismissed. However, the learned tribunal is requested to expedite the matter and to dispose of the same in an as early as possible. The petitioner shall obtain a certified copy of this order and place the same before the learned tribunal within a week from today.
Number 6.
So in this case, the plaintiff examined his witnesses. Plaintiff number 1 and 2. Thereafter, the case was fixed for the defendant witnesses. On the first day, the defendant sought for an adjournment. And next day, the defendant given a list of witnesses. As the plaintiff was not present, this suit was dismissed for default. Now, if it goes against the order 17 rule. Order 17 rules. True explanation. I put in the order 17 at page, paragraph 16. Paragraph 16 of my application. Yeah. Sorry,
Order 17 rule.
Rule 1. But it is written there order 19. But it should be order 17. Page 17. This is not only against the order 17 rule 1, but also the explanation to the rule said order, which state where the evidence or substantial portion of the evidence
or any part has been recorded and such party fails to appear on the day to hearing of the suit is adjourned, the court may, in its discretion, proceed with the case as if the party were present. So it was incumbent on the part of the defendant to file their affidavit on evidence.
Whether after dismissal of the client, you have filed any petition before the trial court for restoration of the suit?
On no, blood, that was not filed, but it is apparently it goes against the order 17 blood. And I have got some judgment also.
Order 17 rule 1.
One explanation. Rule 2. Procedure if the parties fail to appear on the day fixed, where on any day on which the hearing of the suit is adjourned, the parties or any of them fail to appear, the court may proceed to dispose of the suit in one or of the mode directed in that behalf. Order 9 to make other orders as it thinks fit. Now, let's come the explanation. Where the evidence or substantial portion of the evidence of any party has already been recorded. In my case, it was witnesses were examined and cross-examined also. Recorded, and such party fails to appear on the day on which the hearing of the suit is adjourned, the court may, in its discretion, to proceed with the case as if such party was present. Now they have to file their affidavit and evidence. Brought some judgment.
So the court had applied its discretion.
Oh, yes, not that, but despite this, I have some judgment.
Hmm.
High Court judgment. One is AIR 2010 AIR Guwahati, page 66.
Which paragraph you have relied upon?
Paragraph 20. That apart, I have some other judgment of Supreme Court. By reading, where the legislature in their wisdom specifically enumerated the provisions in the code that what has to be done when the plaintiff of the suit is absent and the defendant is present. The court cannot pass any order in contravention of the said provision like Order 9 ruling of the court. What is in the instant case, the trial court did. There are two parts of the civil procedure code. One consists of the section or the rules under the various order. Sections create the jurisdiction of the court, the rules and the order prescribe procedure mandates for exercising jurisdiction based on it. Hence, the procedure prescribed in the code is legislature is not empty formality. The same has to be followed by the court while discharging duties cast on it. Therefore, according to this code, the order of the trial court is contravention of the statutory provision, and thereby the same is to be treated as nullity. And when an order is nullity, that it can be treated also degree. Therefore, the appellant not appealable, but the revisable. When it is revisable, this court has the power to exercise its jurisdiction under Article 227 of the Constitution of India to keep the court below within its limited. Next judgment. That my submitted 2019.
Oh, why don't you file an application before the learned trial court for restoration of the suit?
Apparently, Srisha is against this order. Okay. Because it is, my evidence was closed.
So
was
you
also
prefer this,
cross-examined.
because
The-
of this limitation, you have filed this petition under 227.
No. So what is that?
No, the usual course is to file an application before the trial court to restore the suit.
My lord, may I relay another judgment, my lord?
Hmm.
So for the limitation is concerned,
Hmm.
point of limitation.
Now, therefore, you have filed this application under 227.
Yes, my lord. For the time of limitation, my lord, maintain the delay in laches, no prescribed limitation prescribed for filing the petitioner under Article 227.
Hmm.
If the petition is filed within some delay.
No. I am not raising this issue here. Because of the limitation, you have filed this petition under 227.
Again, judgment, another judgment, my lord, that it can be said, the 2019-11 SCC 301. 2019 में done हुआ।
Which paragraph you have relied upon here?
Paragraph 19. Mary.
Yes.
Order 17, Rule 2 of the Code of Procedure provides that where and on any day to which the hearing of the suit is adjourned, the parties or any of them fail to appear, the court may proceed to dispose of the suit in one of the modes directed in their behalf by Order 9 or make such order as it thinks fit. Now, paragraph 20, the explanation appended to the Order 17 to Rule 2 of the Court provides that where the evidence or a substantial portion of the evidence or any party has already been recorded. My case is that plenty of witnesses were examined and clear for examined. And such party fails to appear on the.
Okay, Mr. Dasgupta, let notice go at this stage.
Obvious, much obliged.
Heard Mr. A. Dasgupta, learned senior counsel assisted by Mr. Learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 3/9/2022 passed by the learned Civil Judge number 1, Kamrup M. Guwahati in Manuscript number 218 of 2011. It is to be noted here that by the implemented order dated so, the learned Civil Judge number 1, Kamrup M. Guwahati has dismissed the Manuscript number 218 of 2011. Dismiss the suit for default. Having heard the submission of Mr. Dasgupta, learned counsel for the petitioner, it is provided that notice be issued to the respondent returnable in 4 weeks. Is that be taken by registered post with AD within a week from today. Please the matter after 4 weeks. Is there any interim period?
No, I don't have anything.
No.
Item 7,
Much obliged.
This petition has been filed against the Lordship in Impin order dated 15/7/2023, Lordship. However, Lordship directed to demolish the existing structure. The lordship and hand over the cash possession of the 1/4 share of the property lordship. Now lordship, fact of the case is that lordship. Lordship, decree holder lordship filed the title suit lordship for partition of the suit property lordship. And lordship petitioner is the wife of the lordship. This is father of the respondent all the respondents lordship. Lordship, respondent number 1 lordship. He resides in a matrimonial house lordship. He is not residing in the lordship petitioner lordship. Now lordship, what happened lordship? The respondent number 1 lordship filed title suit number 9 lordship of 2005, which is even renumbered as 120 of 2006 lordship, for declaration of owner of 1/4 share the suit property by inheritance, having right title interest and performance of possession, and for partition of the suit property lordship, declaring 20 entities to get 1/4 share lordship. Now lordship, thereafter lordship, the respondent filed their WS lordship and London municipal lordship that have passed the judgment
No,
lordship.
the allegation is that the learned court has passed the order
Lordship,
without hearing you.
the lordship, kindly.
But the first line of the order reflects that the parties are represented.
No, lordship, kindly see lordship, page 67 lordship. And lordship, kindly page 68 next. Status report lordship, which is collected from e-court service lordship. First lordship, case was fixed on 3/6 and next date was 18/7. Then lordship, 18/7.
The order, impugn order dated on 15/7/2023 behind the back of the petitioner. And as such, the impugn order suffers from manifest illegality and therefore it is contented to city the city. The submission of Mr. Malakar, learned counsel for the petitioner, needs further consideration. At this stage, notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. taking note of the
My lord, has it?
Hmm.
Paragraph number 6, my lord. Six and seven.
The question is whether at the stage of argument this amendment is permissible.
Certainly, my lord. Before the judgment, the amendments are permissible, even if there is a, otherwise the law says that before commencement of the trial, before reducing of the evidence, but as there has been a change in the nature and character of the land, the nomenclature of the land, so certainly, my lord, the amendment would be permissible, my lord. And my only prayer before this honorable court is that, my lord, that,
Where is the impugn order?
my lord, the impugn order starts from, my lord, page number 65, my lord. However, this particular issue was completely ignored by the learned trial court as regard to amendment, my lord. The learned trial court has admitted in page number, my lord, 69, that the nature and character of the suit has, land has changed, my lord. But there is no observation as to that regard, my lord. Paragraph, page number 69, paragraph number 10, my lord. So my only prayer is that, my lord, I may be allowed to approach the trial court and file an appropriate application for amendment of the written statement first, my lord, rather than the other, my lord. Let the trial court decide my fate, my lord. Because until and unless I don't amend my pleadings, my lord, I cannot use my evidence. That is the law, my lord, and that is the fact of the matter.
In which part of the order the trial court has admitted that the nature of the suit is changed?
My lord, page number 69, my lord.
60?
69, 69, my lord.
69.
And paragraph number 10, my lord, there. Page number 69, paragraph number 10.
No, that is the contents of the written
lord,
statement.
My lord, it has observed the contents of the my lord contents, but there is no observation or dealing with the issue.
Is it the observation of the court?
My lord, there is no observation as to that regard. That is the problem, my lord. Therefore, I'm praying that I may be allowed to file an application under order 6 rule 17.
Let notice go the other side enter appearance.
My lord.
We'll see.
My lord.
Third, Mr. Arsenso, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India and Section 115 and 151 of the Code of Civil Procedure, the petitioner has challenged the correctness or otherwise of the order dated 38/5/2024 passed by the learned civil justice senior division number 2 Mongoldo. Is to be declared that by the order dated so the learned civil justice senior division number 2 Mongoldo has dismissed the petition number 149/2024 and petition number 150 of 2024 filed by the petitioner entitled suit number 133 of 2013. For summoning Latmantal and the submission of original documents respectively. So where was your pair for filing amended written statement?
My lord, that is the problem, my lord. Because these provisions, 3-4 provisions have been clubbed together and an application has been filed under 151. That is the problem, my lord. It ought to have been filed under separate provisions of law, my lord. I'll fairly submit before the honorable court, my lord. This is prima facie. These petitions ought to have been filed under separate provisions of law. Firstly, under order 617, then, my lord, adducing of the evidence, my lord, fresh evidence. In fact, they ought to have been provided with an opportunity. And on the other hand, if that is being intimated to the court that there is a change in the nature and character, there is a change in the suit land, the plaintiff ought to have filed an application for amendment of the my lord plate. Because otherwise he won't be entitled to ultimate relief, my lord. If the plaint has been.
So let the other side appear, we will see. Having heard the submission of learned counsel for the petitioner, it is provided that notice be issued to the respondents, returnable in 4 weeks, step be taken by a third with AD and authorized process. Within a week from today. And considering the submission of learned counsel for the petitioner, and also considering the facts and circumstances on the record. Further proceeding of title suit number 133 of 2013 stands state till returnable date. List after 4 weeks.
May I pray, my lord? This suit is fixed on 9th, my lord. If I may be allowed, I can file them if I'm to service through one of the council.
Dusty is permitted.
Items for admission, item number 11.
May I please also? Well, matter pertains to non-payment of pension. Family pension.
Pardon?
Matter pertains to my lord regarding non-payment of pension.
Yes.
Family pension. My lord, originally, my lord, original petitioner died. Thereafter, my lord, the wife of the petitioner substituted. He's died on my lord 12/7/2023. My lord, he retired. He took volunteer retirement, my lord, on 1/2/2018. Till then, my lord, pension had to be finalized. On the ground that, my lord, page number 49, there is a, my lord, personal loan from a private financial institution. Therefore, my lord, my pension paper has been rejected. At page number 49, this is written by the principal of the school. Page number 49.
Who is for respondent number 7?
7, my lord, appeared.
I am appearing on behalf of the principal. My lord, he is entitled to pension, that is right. But he is also, my lord, to pay the loan amount for which, my lord, everything is kept pending. That is also right. So whatever direction is given, my lord, will act, my lord, to have a principal. My lord. I have no such rule, my lord, not to pay or pay, my lord.
Can on this ground the pension paper may be rejected?
No. It is not correct. It is not correct that principal has the rule to cancel the pension.
Page now 49 is there also.
No, my lord.
Moreover, my lord, for recovery of
This is the wrong allegation.
cannot be withheld, my lord. There is a apex court judgment also. There is a defined procedure for recovery of the loan. They may file title suit, money suit for recovery of the loan. From 2018, now, my lord, 6 years. In the meantime, original petitioner died, now substituted by the wife. 6 years gone also.
So Mr. Sikdar, you would not file this affidavit in opposition here.
My lord.
You were not interested to file affidavit in opposition here.
My lord, because my lord will file an affidavit. Will file an affidavit. I will be given some time. But so far my understanding, my lord, here in this case, my lord, if lordship direct, my lord, to dispose of the claim, my lord, you will cooperate with the, my lord, to comply the order.
Lordship, there is also a order, my lord, 19/6/2024, whereby I was directed to submit something, Lordship, photograph, PAN card, car card, before the authority. I have accordingly applied, submit before the authority, which is not till then, my lord, not acted, Lordship. 19/6/2024, there is a order, Lordship, from this honor.
19/6.
Yes, Lordship, 19 June, Lordship. Accordingly, I applied for process of my pension, my lord.
Nineteen 6/2000.
24, Lordship. The petitioner is directed.
Not 19/6, it is 14/6. Oh yes, 19/6.
Accordingly, I have submitted, madam. DDL has certificate, bank passbook, specimen signature, everything. Till then, no response.
So, where is the order by which your pension paper was rejected?
My lord, page number 49. This is not a order, my lord, this is a communication. whereby-
49.
Yes, lordship. Whereby it can be inferred that due to my loan, the pension paper is not processed. 49, lordship. Third paragraph. Further, the authority directed to understand to held up the pension benefit, held up. If you have not carried out the instruction of the above.
Authority directed, which authority directed?
I think that's all. It may be my lord from the department, director,
Who is for director of secondary education?
secondary.
I may paying for.
I'm appearing for Director of Secondary Education, Lordship.
Yes.
I'm appearing. Lordship, till now we have not received any proposal from the principal, Lordship.
You have not received.
Yes, Lordship.
But on what basis it is a letter was written by Mr. Sigdar?
Well.
That's page number 49.
Well.
It was the letter written by respondent number 7.
Principal.
So you see this further the authority directed to undersign to held up the pension benefit.
Yes, my lord, the authority, my lord, whatever direction given to the principal, he has complied, and he informed that the authority directed, higher authority directed to held up the pension procedure, and because he needs to clear the loan amount from her, that he has not done. That is the problem. And my authorities directed me to not to process, and
Is it a verbal direction or written direction?
well, I may be given some time, but I
Okay, we'll take it up at 2 o'clock. You, in the meantime, you obtain verbal instruction over phone.
Six years loan, lordship.
2 o'clock.
Lordship.
my lord, related to on Monday, my lord, I have to leave.
It's on this side.
Pardon?
I have to leave early. I have to leave the court early, my lord. I have to go Delhi, my lord. I have to
No, we are contemplating to dispose of the petition today itself. You obtain verbal instruction.
Item 12,
My lord, lordship, issue direction will proceed the, my lord, his claim.
Lordship, my lord, without instruction, my lord.
May be processed, my lord. We do, the proposal may be processed, my lord. That may be, direction may be given and comply with that.
it come this side.
My lord, without instruction, my lord, again, my lord, there will be pending, lordship. Instruction not coming.
My submission is, my lord, let the process may be, direction may be issued to process, my lord, from my side, and I will process my.
Lordship, already there is a direction on 19/6, lordship, to submit my papers, lordship. I accordingly submit, lordship. But till then not respond, lordship. 19/6 is order is there, lordship.
Okay.
My lord, if lordship give me direction to send the proposal, I will send, my lord. And that way, my lord, his grievance will be redressed, and he is also obligation to pay the amount that may also be taken care, my lord. The other side, my lord, the hard to, my lord, is also raising claim that he has not cleared the amount. That may also be observed to clear.
We are not concerned with how the other side will recover the loan amount.
Lordship, as the lordship say.
Lordship, there is a.
We'll act to forward the proposal, my lord.
I have furnished on judgment, Lordship.
Yes,
Regarding
what
my
is it?
loan amount cannot be recovered from the pensionary benefit. These are judgment, Lordship. Paragraph 3 and 6, Lordship. They may initiate another proceeding, Lordship, to recover my the loan amount from the pensionary benefit. It cannot be. Please clear, Lordship. Paragraph 3 and 6. There is a other forum, Lordship.
Is anybody representing Hatkul?
In fact, Malad, there is a, to my knowledge, Malad, there is a title suit pending for recovery of the loan in the Kamru.
Yes.
Their instruction was. There is a case
We
pending.
have got the title suit pending, we will recover it from there.
Okay.
I have no objection to recover from the title suit. From the pensionary benefit, it cannot be.
And where is that letter? Page number
Lordship, page number 49, Lordship.
49.
Yes, from my petition.
Heard Mr. Gogoi, learned counsel for the petitioner. And Mr. Your good name?
B. Chaudhary,
B. Chaudhary, learned counsel for the respondent number.
8, 9, 10.
Respondent number 8, 9, and 10.
Yes.
And Mr. Sikdar, learned counsel for the respondent number 7. And Mr.
Lordship. I'm appearing for
Akuria,
respondent
learned
5 and
counsel for the respondent number
5 and 6.
5 and 6. And Mr. Pegu, you were
For respondent number 2 and 4.
2 and 4. And for respondent number 1 and 3,
Here I am representing.
3. Mr. Sakurati, learned counsel for the respondent number 3. And for respondent number 1, State of Assam,
One, 1, 5 and 6, the same.
One also. Lordship.
you.
Yeah.
Okay. This petition under Article 226 of the Constitution of India, the petitioner, namely Drunokanto Das,
The original.
the original
Yes, Lordship.
amended cause list or amended cause title.
I have submitted. Lordship.
On the date of Drunokanto Das, his legal heir, Rono Das, has spread for issuing direction to the respondent authorities to release the service benefit and pensionary benefit with arrears. The grievance of the petitioner is that The petitioner joined as subject teacher in Morrigan SS stroke MA school in the year 1985, and he took voluntary retirement on 1/2/2018. After retirement, the petitioner applied for the pensionary benefits, but his pension and other service benefits are withheld by the respondent authorities on the ground that he had an outstanding loan with HATCO. The respondent number 8, 9, and 10. And until a loan clearance certificate is submitted by him, his pensionary benefits will not be released. The petitioner had communicated that once he received the benefit, he will adjust the same against the loan. And he had no other means to repay the loan. And despite such assurance, the pensionary benefit of the petitioner was withheld in an arbitrary manner. Mr. Gogoi, learned counsel for the petitioner, submits that after retirement, the petitioner has submitted his pension papers with the respondent number 7. But the respondent number 7, by this letter dated 16 May, no, 3rd of May 2019, informed the petitioner that the authority has directed him to held up the pension benefit until and unless the payment of the dues of HATCO authority is cleared. Mr. Gogoi further submits that for recovery of the loan amount, the respondent number 8, 9, and 10 had already instituted one suit before the before the civil court at Morrigan, and that in view of non-payment of the loan amount, the authority cannot hold up the pensionary benefit of the petitioner. And in support of his submission, Mr. Gogoi has referred to a decision of High Court of Madras at Madurai in A. Muthia Bhakkal versus the State Bank of India and 2 others, reported in 2015 SCC Online Madras 13308. Under the given facts and circumstances, Mr. Gogoi submits that the respondent authorities may be directed to release the pensionary benefit. The learned counsel for the respondent number 8, 9, and 10 submits that they have already instituted one civil suit for recovery of the loan amount. What is the number of the suit? What is it?
My lord, the suit is pending in Kamrup Metro, Civil Court, not in
Not
Morrigan.
there. Acha, okay. Kamlok Metro. In which court? Municipal court or civil judge?
Civil just 2, I think.
Senior division. Civil judge, senior division number 2.
I'll provide.
And Mr. Thakuria, learned counsel for the respondent number. Which respondent number 5,
PS 429 of the.
5, 6 and
156.
1, 5 and 6. Submits that they have not received a proposal of pension papers of the petitioners. On the other hand, and as such, the process could not be started. On the other hand, Mr. Sigter, learned counsel for the respondent number, submits that if this court is pleased to issue direction to the respondent number 7, then the pension papers of the petitioner will be processed. But having heard the submission of learned advocates about the parties, I have carefully gone to the petition and the documents placed in the record. And also, where is the case law referred by Mr. Gogoi, learned counsel for the petition. It is not in dispute that the petitioner took voluntary retirement. The petitioner was serving as a subject teacher in Morrigaon SS / MB school. And he took voluntary retirement on 1/2/2018. It is also not in dispute that the pension and other service benefits of the petitioner has not been released. And it was communicated by letter dated 3/5/2019 by the respondent number 7 that he was directed by the authority to hand up the pensionary benefits unless the loan amount due to the HUDCO authority is cleared. It appears, however, it appears from the judgment referred by Mr. Gogoi in Moti Bhakkal within Begat Supra that putting on hold of pensionary benefits on account of non-payment of loan account is not permissible. In holding so, the Madras High Court has relied upon a decision of Honorable Supreme Court in the case of Radheshyam Gupta versus Punjab National Bank, reported in 2009, 1 SCC 376. Taking note of the decision referred by Mr. Gogoi and also considering the given facts and circumstances on the record, as well as the submission of the learned advocates of both sides, this court is inclined to dispose of this writ petition by directing the respondent authorities, especially respondent number 7, to process the pension papers of the petitioner within a week from the date of production of a certified copy of this order, and also clear all the pensionary benefits of the petitioner within a period of 3 months.
Right.
Mr. Thakuria?
Yes.
3 months. In terms of this writ petition is not disposed of.
Title number is there, page number 44. I have next. Page number 44. Title should 429/2019. HUDCO LTD versus Dono Contoras. Pending senior civil just one.
429 of 2019. Atco Ltd versus Runa Kankudas. In view of order passed in WPC number 5795, the IA, which indicates civil number 3647 of 2023 stands closed.
Hello.
May I please, my lord? It's a testamentary appeal, my lord. We have the full judgment dated 2/8/24. Passed by learned DCS, Kamrup at Amingaon. In probate title suit number 2 of 6 of 15, my lord. Impugned judgment is, my lord, at page number 49. And the operative part of the order is at page number 74.
Part Mr. Morzul.
My lord, the will is at page number 39. And as per the will, my lord, page number 40, and as per the will, my lord, at page number 41, Srimani Rinkumani Kalita is the appointed executor, my lord.
Okay, we are admitting it.
My lord,
This appeal under section 299 of the Indian Succession Act 1925, read with order 41, rule 1, and section 151 of the Code of Civil Procedure is directed against the judgment and against the judgment dated 0/2/8/2024 passed by the learned district judge Kamrup Amingaon in probate suit number 06 of 2018.
probate title suit, my lord.
Probate title suit number 06 of 2018. Yes, so we noted here that by the impugned judgment, the learned district judge Kamrup Amingaon has granted probate in respect of the last will dated 2/9/2015, executed by late Hemlata Das, regarding the properties mentioned in the will on payment of requisite fees. Produce the memo of appeal and the grounds mentioned therein. Let notice be issued to the respondents returnable in 4 weeks that be taken by registered post with AD and also by usual process within a week from today. Registry shall call for the record from the learned district judge Kamrup Amingaon. List the matter after 4 weeks.
There is an IA, my lord. IA. For stay of the operation.
We will issue notice here.
My lord,
Issue notice here.
Meanwhile, at least till returnable date, my lord.
Let the other side appear.
Till at least returnable date, my lord.
Item 13.
I have been making an interim pay will be considered after appearance of the parties.
As per the office note dated 2/9/2024, all the respondents are appeared, madam. They filed their wakalatnama.
You are appearing.
Lordship defendant of respondent number 1.
Respondent number 1, you are for
2, 3, 4, and 5.
appearance completed,
3 has also filed wakalatnama.
Yes. I'm appearing on.
3 also.
Yes.
This is already admitted.
Admitted, my lord. No, my lord, it was listed for admission hearing, my lord. Today. Order dated 22/4/2024. my lord.
Heard Mr. R. Sensor, learned counsel for the appellant, and Mr. Gogoi, learned counsel for the respondent number
1.
1, and Mr.
M.R. Sodial.
M.R. Sodial, learned counsel for the respondent number 2, 3, and 4.
5. 2, 3, 4, and 5.
2, 3, 4, and 5. Office note dated 2/9/2024 indicates that LCR has already been received. Admit. Since the LCR has already been received and the parties have already entered appearance, recessal is the matter for hearing in usual course.
Lordship, I may be served a copy.
Yes, Mr. Sodial, learned counsel for the respondent number 2, 3, 4, and 5 submits that he has not been furnished with a copy of the appeal, memo of appeal. Mr. Sensor, learned counsel for the appellant, undertakes to furnish a copy of the memo of appeal to Mr. Sodial during the course of the day.
Deep lords.
Item number 15.
Yeah, please, your seat, my lord, my suit for divorce was dismissed, my lord. That is page 21, my lord. My lord, as per the impugn order, my lord, it was held that I could not prove desertion. Only on the ground that I could not prove desertion, my suit was dismissed. But the other aspects of the matter regarding cruelty was not considered, my lord. The suit also proceeded expertly against the respondent, my lord. We issued paper of application also, then also she did not appear to contest the case. Annexure 4 is the impugn order. Page 21. Para 8, 9, 10, 11.
Heard Mr. I. Sodori, learned counsel for the appellant. This appeal under section 28 of the Hindu Marriage Act 1955 is directed against the judgment dated 25/6/2024 passed by the learned additional district judge number 2 Nagaon matrimonial suit which implicate divorce number 60 of 2023. Peruse the memo of appeal and the grounds mentioned therein. Let notice be issued to the respondent returnable. Admit. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a computer. Call for the registrar call for the record from the learned. Additional procedures. Number 2. Nagaon Assam. Place the matter after 4 weeks.
Average.
Item number 17.
Might be wrong. Hello, this is an appeal, statutory appeal under order 43 rule 1R. I was the defendant in the suit. On the prayer of the plaintiff, a temporary injunction has been granted and it has been finally decided, my lord. I have come against that. My submission is, my lord, appeal may be admitted as far as my prayer for stay is concerned. That I'll press in the presence of the respondent. So notice on the interim IMA.
Heard Mr. D. Mazumdar, learned senior counsel, assisted by Mr. Learned counsel for the appellant. This appeal under order 43 rule 1, within bracket smaller. The Code of Civil Procedure 1908 is directed against the order dated 4/6/2024 passed by the learned civil judge
Senior
Number.
Division 1, Silchar.
Senior Division number 1, Kasar Silsor.
In Miss J case number
Mistake case
204
number
of 20.
204 of 2023 arising out of title suit number 127
127.
of 2023. It is to be noted here that by the on order dated so and so, the learned civil judge senior division number 1 Kasar Silsor has allowed the care of temporary injunction.
Defendant's case has not been discussed nor decided anything. Lord, you may admit
Where
the
is
appeal.
the memo of appeal and the grounds mentioned therein? Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Registrar, whether record will be required?
Records at this stage may not be
Not
required.
necessary.
Well, as far as the appeal is concerned, my lord, the other side has got no right to oppose. Appeal may be admitted. This is the procedure, my lord.
Admitted, yes.
Appeal is admitted. So far as IA is concerned, Lordship may issue notice. I'll pray for the interim order in their presence.
IA issue notice
IA
on
2469.
appearance of the parties, the interim care will be considered.
Brief, Lord.
Item 18.
May I please, your lordship? Partition appeal under order 43 rule 1R, reading section 151. So here, my lord, my prayer for an interim injunction was not granted. Only notice was issued by the Learned Court of Civil Judge Senior Division number 3, Kamarav Metro, in Mizze case number 674 of the 24, arising out of PS number 361 of the 24. So this is basically for the specific performance of contract, confirmation of position, my lord, and it is my specific case in para 16 that the water supply connection is disconnected by the defendant. I paid the total consideration amount of rupees 27 lakhs for purchasing the property. Thereafter, I incurred another cost of, my lord, rupees 29 lakhs for building the structure. So, in para, lordship will find at page number 42, para 16 of my plaint. This is the very crux of the matter. Memo of appeal, page number 42, para 16. That finding no other alternative, the plaintiff remained silent and decided to wait for some more times. Thereafter, in the month of June 2024, the defendant installed a water tank covering 6 feet by 8 feet area on the northeastern part of the roof which has been intended to be purchased by the plaintiff from the defendant and for which the entire consideration amount has already been paid by the plaintiff and is under the possession of the plaintiff, and on that the wife of the plaintiff objected and tried to stop the defendant from doing so. But the defendant did not pay any heed to the same and threatened the wife of the plaintiff not to disturb and asked her to keep silent. However, as the wife of the plaintiff kept objecting, the defendant and
Okay, we will issue notice that this is this. We will admit the appeal. Heard Mr. B. Bora,
B. Bora.
learned counsel for the appellant. This appeal under order 43 rule 1. But it becomes smaller, read with section 151 of the Code of Civil Procedure is directed against the interim order, against the order dated 25/7/2024, passed by the learned civil judge senior division number 3, Kamrup M. Guwahati in Misji case number 674 of 2024, arising out of titles of number 361 of 2024. It is to be noted here that by interim order dated so, the learned civil judge senior division number 3 has dismissed the petition filed by the appellant under order 39 rule 1 and 2, rated section 151 CPC. There is the memo of appeal and the grounds mentioned therein. Admit. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process. We can come to that. Release the matter after 4 weeks. In IA, we will issue notice.
My lord, kindly, I am confined only to the restoration of water supply as on date. On the other aspects, I am not pressing. Today, my lord, I am purchasing water since the month of June.
Let the other side appear, we will see.
Only to the
Then
restoration.
IA, then we will fix a very short date,
Yes.
2 weeks.
Item 19.
May it please your lordship. Lordship, a talk of compromise is going on between the parties. Kindly this matter may be fixed in the upcoming Lok Adalat, lordship.
After that,
Lok Adalat, lordship.
before look at the law.
No, maybe fixed in the Lok Adalat, lordship.
This matter,
Yes, lordship.
without admitting it.
If lordship, as per lordship, sorry.
No, unless it is admitted, how can we direct the registry to place it
Maybe-
before the look at the lot?
And then lordship, we have filed this appeal on the ground of quantum, lordship.
What is the ground?
Income and occupation was not proved, lordship. There was not credible evidence. There was no credible evidence to prove the income and occupation of the deceased, lordship.
Or Miss M. Soikia,
Yes.
learned counsel for the appellant. Judgment and award dated 8/7/2024, passed by the learned member MSCT number 2, Kamrup M. in MSC case number Kamrup M. Guwahati in MSC case number 991 of 2019. Is put to challenge in this appeal under section 173 of the MB Act. It is to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed the appellant United India Insurance Company Limited to pay a sum of rupees. What was the quantum?
26,47,814.40.
A sum of rupees 26,47,814.40 with 9% interest. 9% interest. From being the compensation to the respondent. Peruse the memo of appeal and the grounds mentioned therein. Admit. Issue notice to the respondent. Returnable in 4 weeks. Step be taken by registered post and also by usual process within a week from today. Call for the record from the learned member MSCT. Number 3, Kamrup and Guwahati. Number 2, the learned counsel for the appellant submits that this matter may be referred to look at a lot to be held on 14th of September 2024. Accordingly, it is provided that register list the matter before the look at a lot to be held on 14/9/2024.
Mayor, in this matter regarding provincialization of petitioner service, my lord, DLC, my lord, recommended the case of the petitioners, my lord, and send the proposal before the associate, my lord. But this matter is covered by order of this honorable court, my lord, similar.
My lord, I have received instruction. As per instruction that concerned school does not have title over the land. So as per requirement of it, only possession certificate is there, but however, no registered deed, allotment land, copy of Javamundi, your put is report a concerned DO.
Worship, I may be allowed to furnish all the documents before the SLC, my lord. With a fresh representation, my lord. I have annexed also, my lord, the indirect petition.
So, as per this letter, the school does not fulfill the condition of valid land document to prove the land in the name of the said school.
Worship, DLC while recommending my case, my lord, all the necessary document were verified, my lord.
Pardon?
Then, when the my lord DLC recommendation my case, my lord, on 6/2/2018, my lord. My case is recommended, my lord, page 23, my lord, annexure 6, my lord,
Page 20.
23, my lord. Annexure 6. The relevant portion is, my lord, 24, my lord. Abdul Fattah, my lord, bottom, my lord, in the bottom, my name is Abdul Fattah, recommended, my lord. Sharif Hussain, recommended, my lord. Rapna Begum, my lord, recommended. All the petitioners are recommended, my lord. After due verification, my lord. Then, my lord, annexure 7 is the proposal, my lord.
Here, my lord, DLC has recommended it, but state level committee has rejected the claim of petitioner.
Which committee?
State level committee.
State level committee.
There is a two committee, district level committee and state level committee. The state level committee has rejected their claim because their title, land title is not there in the name of the school as per requirement of the state.
Worship,
So only possession certificate is there. It is not enough.
Worship circle officer report maybe there, my lord, annexure 10, my lord. Page 31.
Have you seen this letter? This letter?
No, my lord.
So, if furnish a copy to him,
Well,
then he will have to obtain necessary instruction in this regard.
I may allowed to furnish all the documents before the SLC, my lord.
Okay.
And
Heard, Mr. Your good name?
HL also, my lord.
SL Oscar, Learned Counsel for the petitioner, and Mr.
G figure.
G. Pego, Learned Counsel for the respondent numbers.
Respondent number 1, 2.
Respondent number 1, 2.
And 3, my lord.
1, 2, and 3.
And 5, 6.
And 5, 6. Who is for 4?
I appear for 4.
4. And Mr. Pego, Learned government advocate for respondent number 4. The Learned Counsel, no,
Sir,
Mr.
my lord, there is a one provision for appeal. If he is not satisfied with the state level committee, section 14 is provided for the appeal. He may
Filed, my lord.
file
I filed,
appeal,
my
my lord,
lord,
statutory appeal.
I annex also, my lord. Lordship, annexure 8, my lord. This appeal was forwarded to the director, my lord. Annexure 8, page 28, my lord.
Page number
Page 28, my lord.
28.
Serial number 5, representation of Abdul Fattah is forwarded to the
Mr. Pego, Learned Counsel for the respondent number so and so has produced a letter at the Director of Elementary Education, Palipara, Guwahati, dated 21st June 2024. And submits that the aforesaid school of the petitioner does not fulfill the condition a valid land document to prove the land in the name of the said school with clear and exclusive title and position over the land before 1/1/2006. For which the said school could not be recommended by the state level scrutiny committee. The learned counsel for the petitioner submits that he may be permitted to produce all the relevant documents before this court. There is accordingly allowed, list the matter when
After 1 week.
after 1 week. Should we keep it as parted? List the matter as parted. A copy of the letter produced before this court by Mr. Pegu be furnished to to the learned counsel for the petitioner. List accordingly.
21.
May I please your lordship?
Mm.
Your lordship, this is an appeal preferred by the claimant for enhancement of the awarded amount.
Heard Mr. Mandal, learned counsel for the appellant. This appeal under section 173 of the MB Act 1988 is directed against the judgment and award dated 16/5/2014 passed by the learned member MSCT Karnov Amingao in MSC case number 121 of 2019. Mr. Mandal, learned counsel for the appellant, submits that this appeal is preferred for enhancement of the awarded amount.
Your lordship, my permanent disability has not been considered.
And further, Mr. Mandal submits that while assessing the compensation, the learned member MSCT has not considered the permanent disability suffered by the appellant
And your
and
lordship,
awarded a sum of rupees. What was the quantum? $2,43,233. The submission of Mr. Mandal, learned counsel for the appellant, needs further consideration. That is this. Admit the appeal, issue notice to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by observed process within a week from today. Call for the record from the learned member MSCT Amingao. Place the matter after 4 weeks.
22.
oblige your lordship. May I please your lordship? Lordship, in this case, I am appearing as a caveator. And this is listed for the first time. The appeal has been preferred by the insurance company. And
Okay, caveat is then research.
my prayer is that the appeal may be listed before the ensuing lok adalat to be held on 14th of this month.
Your lordship, we have received instructions from the insurance company and they have also agreed to settle the matter in the ensuing lok adalat.
Okay, we will admit the appeal. Thereafter, we will direct the registry to list the matter before look at the law.
May I please your lordship? Your lordship, there are instances in which even in the stage of delay application, the appeals are settled. So this is not the criteria that prior to admission, it cannot be settled. Your lordship can admit it, but even without admission, because there is stay application. So if
if the settlement doesn't succeed, then it may be listed and with the admission. Mr. Mandala, I have passed some orders just before this case. Yes, your lordship. In which after admitting the appeal, we have directed the registry to
Yes,
fetch
yes.
the matter before look at the law. Then why you are submitting it? No, your lordship, it is not precondition. That was my submission. Yes, heard miss, your good name?
A Biani,
Learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act is directed against the judgment and award dated 30th/1/2024, first fatal learned member MSCP Kamrup M in MSC case number 204 of 2015. It is to be noted here that by the impugned judgment and award dated so and so, the learned member MSCP number 1 Kamrup M has directed the appellant United India Insurance Company Limited to pay a sum of rupees 86,57,568, being the compensation with 6.5% interest per annum from the date of filing the claim petition on claim petition, that is 9/2/2015 till realization to the respondent hearing. Where is the memo of appeal and the grounds mentioned therein, and also heard Mr. Mondal, learned counsel for the respondent. Admit, issue notice to the respondents, returnable in 4 weeks, step be taken by registered post with AD and also by usual process. Since you are representing all the respondents. No, 1, 2, and 3, all claimants responded. Since Mr. Mondal appeared and received notice on behalf of respondent number 1, 2, and 3, no formal notice is required to be issued. However, extra requisite copy of the petition furnished during the course of the day. The special call for the record from the learned member MSCT number 1 Kamrup M, Guwahati. Miss Biani, learned counsel for the appellant, submits that the matter may be placed before the Lok Adalat to be held on 14th of September 2024. Mr. Mondal, learned counsel for the respondent number 1, 2, and 3 also. Your lordship, I'm sorry, respondent number 1 and 2. 1 and 2. Okay, 1 and 2. Okay, very good. Also agreed to the submission made by Ms. Biani, learned counsel for the appellant. Accordingly, it is provided that recital is the matter before the Lok Adalat to be held on 14th of September 2024. Your lordship, there is one stay application. So stay application it will be considered later on. Yes, later on. So notice.
23,
Oblige, your lordship.
In this method, I need some time to receive instruction. And 2 weeks after 2.
Heard Mr. N. Sharma.
Yes.
Learned counsel for the petitioner. And also heard Mr. Pegu, learned counsel for the respondent number
1 to 4. 1 to 4.
1 to 4.
1 to 4. Mr. Pegu submits that he may be granted 1 week time,
2 weeks.
2 weeks time to file affidavit in objection. Affidavit in opposition, here is accordingly allowed. What about respondent number 5? Service completed?
The gym completed.
None appears for the respondent number 5. Leaves the matter after 4 weeks. For 2 weeks?
After 2 weeks.
2 weeks.
Date may be fixed.
Okay, I'll give it.
Obliged.
49.
Well,
49.
Lordship, matter may be taken after break. Matter may be taken after break.
Pardon?
Because the contracted counsel can show the another.
I'm not getting you.
Loudly, please.
My brother says that Lordship, matter may be taken
May be
after
taken
the
after
break.
break.
He says.
After break.
Yes.
Otherwise, Lordship, in this case, we have to file affidavit, Lordship.
You want to file affidavit?
Lordship, affidavit is required for adjudication of the issues, Lordship. It's a 24 matter, Lordship, admission matter. Lordship.
Okay, then add 2. Let his senior come.
Lordship.
Let us say,
For bail hearing, 24.
I'm sorry, my lord, is there not received, my lord. One chance may be given, my lord, next week.
So many deeds has gone. I am not quite innocent. My name is not in the FIR also, not very. I am no way connected with the case.
maybe, but you have not complied with the order, and on that ground, we can dismiss the petition.
That
But
was,
we are not dismissing it.
that interim bail was cancelled
No.
on 19.
On the next week, my lord, I'll put it. Earlier, my lord, I was
Or Mr.
on
Gustaf
leave.
Learned Counsel for the accused, applicant, and Mr. Parasar Learned additional PP for the status, and then Mr. Parasar submits that he has not received the keys AD and prays for granting him last opportunity. Here is accordingly allowed in the event of failing to produce the case AD on next day. The court will proceed to hear and dispose of the application without case AD.
13, my lord, 39.
13.
Even
13.
13.
Item number 25 for hearing on order 41 rule to CPC.
I filed his second appeal only on one question of law, section 90 of the Evidence Act. There is a case, my lordship, that I have claimed title over a particular suit land on the basis of a document which is more than 30 years old. My lordship. My lords, the appellate court gave the observation that the burden of proof lies on me, my lordship. And para 18 of the appeal, may be seen, my lordship. Para 18, page 23 of the petition.
So, whether this number one substantial question of law can it be a substantial question of law?
Yes, my lordship.
How?
My lordship.
So it is provided by the statute that 30 years in the event of documents of 30 years old presumption is available.
Is in my favor, my lordship.
Hmm?
And that, my lordship, if it is in my presumption is in my favor, then the burden of proof lies with the defendant, my lordship. Because I have produced the document, on the basis of which I am claiming title, my lordship. The question cannot be raised against that document which I have produced from a registered document, my lordship. And it was never questioned, my lordship. Even the sale deed was never questioned in any suit.
But when it is registered before an authority, it should be presumed that it was registered by following all the due process. So my lordship, at this stage only notice may be issued.
Hmm?
At this stage, my lordship, only notice may be issued.
No, unless we admit it, we cannot issue notice.
Yes, my lordship.
The question is whether these are substantial question of
Yes,
law
yes,
or
yes,
not.
my lordship.
Hmm? So number one cannot be because it is well settled. So burden of proof that is provided in the Evidence Act
My lordship.
upon whom burden of proof lies.
In the,
How can it be a substantial question of law?
my lordship, in the burden of proof,
Hmm.
as per section 101 and 102, it lies with the plaintiff, my lordship.
Hmm.
And when presumption comes in my favor, then the burden will shift my lordship, to the
Hmm.
defendant, my lordship. And now I have produced the document, my lordship, which is more than 30 years old, my lordship. And it is presumed that it has been registered by following the due procedure, my lordship. Then it is the burden of the defendant to prove that it was not executed by following the law.
You examine these questions again. We'll list the matter for further hearing.
Yes, my lordship.
Heard, Mr.
Yes, my lordship.
Learned Counsel for the appellant. I'll list the matter on. Kobe, when?
After vacation,
No, sort that. Before
On-
vacation
on 25 September.
for further consideration.
My lordship, there is a correction, my lordship, in the cost title, my lordship. They have cost title, some minor correction is required, my lordship.
Correction, there is procedure provided for making correction. You follow that procedure.
There is no fault in our part, my lordship.
Whose part?
My lordship, the name of the petitioner Abdul Majid Khan, my lordship. But while registering the case, my lord, it has what? Abdul Mandal, it has come, my lordship, in the court list.
Good.
Abdul Majid. Petitioner.
Yes, my lordship. Abdul Majid Khan, his name, but in the cost title, in the cause list, it has come Abdul Mandal.
You approach the registry. Yes.
But challenging the water, it is 13 space 62 is the water lordship, Yukon water lordship. Page 62 lordship.
So here the delay was inordinate.
Delay
One
was there,
thousand 651 days.
lordship.
Okay.
Delay was there, lordship.
Okay.
Earlier
You will
lordship-
issue notice at this instance.
Lordship.
Okay. All right, keep it. List the matter after 4 weeks.
Step.
Pending item 49.
See, in this case, we wait for 4 weeks time to file affidavit also.
Yes,
Lordship,
not present.
2 weeks time may be given first.
Okay, okay. 2 weeks time.
Lordship, at least 3 weeks, Lordship. 3 weeks. We have not received instruction, we have to receive instruction.
Item number 52 by VC upgraded matter.
Yes.
May it please your lord. My lord, the point which has been raised by my learned friend of the last occasion, I have noted down what are the points. I'll give a reply later on. What are the points he has raised before this round? Now, what is, my lord, why we have to move?
No,
before
we
this-
are on the IA now.
I'm sorry, my lord.
This IA.
Your lordship is not hearing the entire matter.
No,
Because
he is argued only on the point of
IA, my lord,
IA.
the IA is for modification and variation of the order that has been passed. Now, suppose it is modified. Let us, for example, that is amounting to, my lord, the FO, nothing remains in the FO. So, if you, my lord, hear the IA, it amounting hear the whole case. Because against an order of injunction, an appeal has been filed under order 43 rule 1R. And
No,
41.
on the other day, Mr. Hazarika has argued on the point of this IA.
If I may make a submission, Manoj.
Yes.
Since my learned friend was not there, I raised my preliminary objections to the maintainability of that appeal. I mean, I have no objection if the appeal is disposed of in its entirety, because after all, we are spending time. So, Manoj, the IA was actually raising the objections to the maintainability of the appeal on the 2 points. That basically there is yes. That
One
the
is
appeal,
that concealment and the other is not complied with the order, non-compliance of the order.
absolutely.
Yes.
My lord,
so, these are my preliminary grounds. Now, if your lordship, because after all, here's the matter and finishes it off, I have no objection to that, because there will be a disposal also of the matter in that sense. So,
my submission, before lordship with great respect, my lord, it has to be heard in totality in this matter. Because, my lord, what happens, an order of
No,
injunction.
Mr. Das, I have no problem.
No, I understand. I understand, my lord, your lordship will not have any problem. But ultimately, hearing the IA amounts to hearing the entire matter. Now, your lordship, if lordship is satisfied that we have to modify the order, that means going back to the injunction, which has been granted in their favor. But an appeal is now before this honorable court. Now it is an ex parte order. Injunction has been passed. Ex parte injunction has been passed. Now, ex parte injunction on a ground, 3-4 grounds I have filed an appeal. My lord, there was a provision under Order 39 Rule 4 for modification or variation of the order. I didn't choose that. I have preferred an appeal under Order 43 Rule 1R and along with it 41.5. Now, the exercise of the power by the appellate court to the extent is when it is arbitrary, when it is perverse. Your lordship, I am aware of the wanton and talks that it cannot substitute what is the arbitrariness and what is the perversity of the order. That's what I want to place it before this honorable court. Now, 3-4 points I have been, my lord, brief my learned friend, and I have gone through it. My lord, it is projected that one, there is a injunction order which has been filed. Now there is application under Order 39 2A has been filed. So we have to comply that order, then we can argue this matter. I think with great respect, I have not, my lord, heard about this proposition of that argument which my learned friend has advanced. That cannot be a case. My lord, my learned friend has shown one judgment of the Supreme Court relying on prestige judgment. Prestige judgment is completely on a different footing. I have gone through that prestige judgment. It was a case, what is the facts? That was a surfacing. 13-2 was issued, my lord. The guarantors that the directors so far are placing that was also guarantee was invoked. 13-2 is completely, I will show what were the facts of the case in prestige. One line bringing para 24 is not suffice. There are other paragraphs. So, my lord, that cannot be a case where number one, there is a violation of the court's order. You comply with that, then only it can be heard. My lord, then each and every case when an injunction is being filed, injunction, that means there will be no option to file an appeal against that order. It's a separate that your lordship will examine that why I will exercise my jurisdiction under 43(1)(r). That has to be, my lord, seen on a context of the case. What is a perversity in the order? Because my learned friend was basing on these 2 points. But what is about the suit? Today, your lordship is examining the veracity of the injunction order, basing on the material. And my learned friend said that there was these materials were not before the court. Enters the FAO along with the copy of the documents was not before the court. So there were a lot of documents which they relied, and while filing the FO, we have not annexed them. So there is a separation. And if that document would have been there, then this situation would have been different. Then the court might not have granted stay. That's what he's saying. Separation. 2 points. One is separation. I'm dealing that, my lord, first. I'm dealing this point first.
No, now you tell me, both the council, are you agree to argue on the point of this appeal?
No, I'm ready to argue on the point of appeal, my lord. Absolutely.
Yes,
there is no-
Mr. Azrika.
So am I. So am I subject to my preliminary objection because my submissions will be as follows. That appeal has to be dismissed at the threshold because of material concealment, 1. 2, because he is in breach of the order, 2. And even otherwise on merits and without prejudice to those submissions, then I will make my submission a response on merits to whatever my learned friend has. And as already indicated to your lordships, they have filed an appeal only on defamation. They have not filed it on other grounds. So I'll make those submissions as well. But it will be basically, my lords, at 2 levels, that my preliminary objections merit a dismissal of the appeal at the threshold. Even otherwise, without prejudice to those submissions, it may still, my lords, it is still not maintained.
So, will you be able to argue through VC?
Yes, my lords, I will be able to do that. Subject only one concession I will seek from your lordship. Let my learned friend complete to that. I can then respond at 2 o'clock on Monday.
Achha.
Because I don't have the benefit of the citations and so I will take them from my Mr. Roy and Mr. Hazarika. And
Okay. Okay.
Yes, I will just, my lord, these 2 points I'll give later on reply. First, what is about this suit? I think there's a foundation of the whole case. What is about the suit? I think it was not addressed before this court. These 2 points were addressed. I like to address what is about the suit first and the injunction they have filed. And injunction in a defamatory case, my lord will kindly be shocked. I will show not only the injunction restraining order was passed, a mandatory injunction was passed. A mandatory injunction was passed. I'll show, my lord, and your lordship. I have also, my lord, seen the order, my lord. Mandatory injunction granting of mandatory, higher pedestal than of injunction under order 39(1) and 2. My lord, not to publish, I understand. There is they said certain articles were being published by us. So, Article 1, Article 2, Article 3, and Article 4. Article 3, I'll go through that much, just putting in a short, my lord. Article 3 is a Hindi version. And this, they said, this particular version you have not annexed in the FAO. And what is the contents of that version? That version is in the FAO. In the body of the case and also the suit. And what is that FAO, my lord? I'll take your lordship to first, what is about who is the plaintiff and who is the defendant, meaning the appellant as well as the respondent. Kindly look into it. My lord, page 5, kindly look into it. My FAO, that is 31 of 2024. Kindly see 5, paragraph 2.
Yes.
That the appellant number 1 is a well-established news website which strongly believes in principle of fair journalism and objective reporting. The online portal of the appellant number 1, so-and-so moneycontrol.com, was launched in the year 1999. Money Control is a prominent financial news and information platform in India, renowned for its legacy and reputation in the field of financial journalism and market analysis. Established in 1999, Money Control has evolved into one of the country's leading financial portals, providing comprehensive coverage of the stock market, startup, business news, investment insight, personal finance. It is owned and operated by Network 18 Group, which also operates CNBC, TV 18, First Sports, Forbes India, and CNN News 18, among others. So this is, my lord, the appellant, who is the appellant before this honorable court. Now, if your lordship kindly see at paragraph 4, that it is opposite to mention Money Control reputation extends beyond news reporting, as it offers a range of tools and resources such as stock charts, portfolio trackers, investment tips, empowering users to make informed financial decisions. Its dedication to transparency and accuracy has garnered the trust of a diverse user base, including retail investors, financial professionals, and business. Money Control stands as a testament to the evolution of financial journalism in India. Its legacy and reputation are built on a foundation of reliable information, technology innovation, commitment to empowering individuals with the knowledge they need to navigate the complexity of the financial world. So this is who is the appellant, that is we have projected. Kindly see what is the plaintiff, who is the respondent in this particular case, at paragraph 5. The respondent here is the company incorporated and registered on the Companies Act, which was constituted in the year 1992, and it's involved in the business of coaching students of various competitive and other exams through physical as online mode. So these are the coaching institute, like Akasdeep we have got, Baiju we have got. These are coaching institute. Now, my lord will kindly look into the title suit at page 36. This is a suit they have filed, my lord. Now, suit for, my lord, kindly see at page 37. Suit for permanent and mandatory injunction, damages on account of defamation and disparagement. So they are seeking one permanent as well as mandatory injunction, my lord. Now, how it started and what made them to file a suit? What made them to file this suit? If your lordship kindly look at page 43, this is the first article which was published by the appellant. Article number 1. Lordship will kindly note down article number 1, 12th of March 2024. At page 43, my lord. On 12th of March 2024, in the morning at 7:38 AM, plaintiff has received an email in respect to an article to be published on defense number 1 platform titled Fitzy holds employee salaries for second month in a row, calls it wake up call to make them work harder. In the said email, defense number 2 sought for clarification in respect of to 13 points of query. Defense number 2 sought a response to this query by 10 AM on the same day, further stating the article shall be published at 11. So this is the foundation of the entire case. And all other related Article 2, I will read that Article 2, Article 3, and Article 4. What are those Article 2 and Article 3 for? While deciding the matter, in this case, before this honorable court, my lord, this Article 1 is most vital. And all these are, other is correlated, while show it, my lord. Now, before publication by us, we wrote some query. We have written to them. Kindly see, my lord, at page 85. Kindly be looked into it. Before publication of this article number 1, at page 85, my lord will kindly see the date. Please see the date, my lord. Manish Verma, Tuesday, 12/3/2024 at 7:38 AM. Now, before publication, we have written to them. Dear Fiji team, I hope this email finds you well. I am Manish Verma, a journalist working with Money Control. I am reaching out for a story I am working on about unpaid salary at Fiji. We have gathered information regarding the company and its management sending mails to his employees stating that the salaries were not paid in an attempt to give them a wake-up call to work harder amid financial troubles and rising competition. We would appreciate if you could kindly respond to the following set of questions. Your detailed insight will help. 1. Has Fiji held back employee salaries for 2 consecutive months, January and February? Number 2, it is true that a company has only paid 50% of January salaries for all employees. Was the salary paid in March, a month later than when it was to be credited? Number 3, when does the company plan on paying the rest of the amount to employees? What is the reason behind salaries not being paid? 4, did the company hold back employee salaries to give them a wake-up call to work harder? 5, has the management written emails to employees justifying the reason behind holding back employee salaries? Now, 6, did the company in the first mail tell employees that their future is their own hands? Did the company ask his employee to commit to achieving the goals? So on, my lord, this particular queries was put forward before publishing this article. And that your lordship will note down at 7:38 AM. We did not publish. We have asked them these queries. If your lordship kindly see at page 86(8), in an email that followed, did the company urge managing partner to act quickly in response to the trailing email and emphasize salary is not a matter of right, but needs to be earned by doing what is expected to them? 9 also. So, my lord, this was put to them before publishing it. And this was at 7:38. Now, we waited. We said that till 10 AM, we want an answer to it. They did not give any answer till 10 AM. That is why the first article was published. Now, if your lordship will kindly see, the first article which was published is at page 93. This is the article, which I read the plaint, my lord, at page 43, article number 1. See kindly, my lord, at page 93, top money control. Fiji holds employees' salaries for second month in a row, calls it wake-up call to make them work harder. Now, my lord will kindly see, in a multiple emails over the first few weeks, the company backed by Matrix Venture Partners told employees that while Fiji does not face an immediate liquidity crisis, it has deliberately suspended salaries to give them a wake-up call to work harder. So all this was based on facts and documents and an email. I'll show it, my lord. So we didn't publish, my lord, without making a query to it. We made a query, and this is why after making a query, this was published. And my lord, we waited till 10 AM. They gave a reply. I'll show the reply. Their reply also, we'll see how it corroborates. So our article which was published, my lord, that was not on air, my lord. It was on basis of some emails which was given by the management to the employee.
Kindly see, my lord. Deliberately suspended salaries to them to give them a wake-up call to work harder. Fiji, one of India's oldest test preparation firms, has held back employee salary for the second month in a row amid stagnating growth and rising competition for its coaching centers across the country. Now, if your lordship kindly to turn to 94 on the second paragraph, according to two executives of the company, backed by Matrix Venture Partner, Fiji paid 50% of January salary last week while holding back the rest. This come after media report in February suggested that the company suspended January salaries on the back of cash flows concern. Now see kindly next paragraph. In two emails that followed over the past few weeks, the company's management told employees that while Fiji does not face an immediate liquidity crisis, it has deliberately suspended salaries to give them a wake-up call to work harder. When we don't follow us and don't do your duty properly at the centers, then we can't run the centers efficiently enough. Coming to the office without clear goals will not take you anywhere. Salary is not a matter of rights. It needs to be earned by doing what is expected of you to do. Said Dinesh Kumar Goel, the founder and managing director of Fiji, in one of the mail sent on March 3. So all these are based on certain documents, on facts. So why the learned trial court, my lord? I can very well understand. Number one, you have restraint for further publicity. You have what you have done, and mandatory injunction was granted for taking down all those articles. This is what we are before this court, taking down all the articles. The learned trial court could have said, yes, I am restraining you not to publish prima facie. The case which they projected, first they want that restraining for publishing. I have understood, my lord, yes, you don't do it. We are restraining you. But where is the question? 3 prayers, all has been allowed. Only what remains is the quantum. Like when an accused has been convicted, the sentence next day it will be pronounced. I'll show it. That is what led to file this appeal before this honorable court. And this is an ex parte order, my lord. Totally an ex parte order. That led to file this appeal under order 43 1R. I'll show this, my lord. And what are their communications? Now, my lord, at page 95, at 95, kindly see a last paragraph. In addition, they added a delay in salaries are due to hold of on employees and in submitting some required information in the ongoing appraisal process. If you see at 96, we are doing appraisal of centers on the basis of system being known to every managing partner, center head, all the employees for the last 15 years. We have various systems to protect the interests of the students and affect society in a positive way. These appraisal are part of the checks and balance. There is delay on the part of centers, red managing partners and employees submitting the required information, and therefore due salaries are yet to be processed, the spokesman further said. So all this goes on, my lord, up to page 100, up to page 100. Up to page 100, my lord. Now, your lordship will kindly see up to page 100. 101. 101. Up to page 101. Lordship got it, my lord. Now your lordship will kindly see their reply. Their reply comes up after publication of the articles. Now you see at page 88, my lord. Page 88.
Their reply
My lord, we before publication of articles on 12/3/2024 at 7:38 AM, we wrote to them.
After publication of the article, you have received the reply.
After publication of the email, we received the reply. We received
then
the reply.
How can your publication based on the reply given by them?
Number one, my lord, the query which has been put forward by them was on 12th of March 2024 at 7:38 AM. we have written to them that please give us reply. These are the queries we are asking to give the reply back to us at 10 a.m., which they didn't give any reply. So we publish this article. After publication of these articles, they come up with a reply to us at page 88.
Page
See
number?
page 88. Page 88. See page 88.
Yes.
Now kindly see the date, my lord. Queries on the top, queries from Money Control, Aditya Sharma, Fitzi. Lordship got it? Kindly see the date, 12/3/2024, 2:34. 2:34. Lordship got it? Now kindly see the third line, third paragraph. First paragraph. See, kindly see the third paragraph. Fitzi
My learned friend can read the first paragraph as well, because then don't need to repeat it.
Yes, I'll read it. Thank you very much. You said, I deeply appreciate you reaching out to us to verify the information. However, the time given was very less. Our office opens at 10 a.m. and we can't access and respond to all emails immediately. Though we gave us time till 12 noon, but we published the story at 11:15 a.m. It's time that you had already created the story and you were predisposed to writing it. It seems that you have already created a story and so. Shouldn't we have given us adequate time, waited for a response and then create the story? What was the hurry? How will this story serve the interest of student committee or education in general? Now, if your lordship kindly see the fourth paragraph, Fitzi has an entrepreneurial and well decentralized system of management. This is unlike most other companies in India. We are doing appraisal of centers on the basis of a system being known to every managing partner, center head, and all employed for the last 15 years. We have various systems to protect interest of the students and affect society in a positive way. These appraisals are part of the checks and balances. There is a delay on part of centers. Managing partners employed in submitted the required information, and therefore due salaries are yet to be processed. So my lord will kindly see the queries which has been put forward. That is a fact. Now kindly see, there is no delay on part of corporate operation. As soon as the centers complete their appraisal related work, due salaries will start getting released. So they've admitted, my lord. Our publication, if your lordship kindly see once again, article, see once again, my lord, at page 93. 93, kindly see, my lord. Fitzi, one of so and so, second paragraph, one of the India so and so firms held back employee salary for the second month in a row and administering growth and rising combination for his coaching centers across the country. So this is correct. Their reply, kindly see whatever you have published. Now, if you read, as soon as the centers complete their appraisal related work, due salaries will start getting released. Despite delays on part of centers, rate managing partner and employees, we have processed a significant part of the salary for January 2024, and on it is humanitarian grounds on promises by the respective teams, we are urging centers to submit the required information as soon as possible. Now, if your lordship kindly now look into first, second, the fourth paragraph, when we are head, lordship got it? When we are head and shoulders above the rest consistently and have such a great brand and mind equity, then there is very little competition. However, the financial performance has nothing to do with competition. The entire engineering test preparation and the foundation course market in which Fitzi operate is worth about 3 lakhs crores. The market is too big. If somebody is failing and having pressure, it is because either the quality or the business team is not good. We have both the quality as well as a good business team. When it comes to producing great result and providing
incomparable students, services, undoubtedly Fiji is number one. Now your lordship will kindly mark it. The only concern is that because of consistent domination in result of various competitive exams and huge appreciation from the students community, our business team is becoming overconfident and entering into a comfort zone. Rather, they should have converted the appreciation received by students and great work done by our teacher into more business, and the wake-up call is only for them. Lordship, this is what we publish. Wake-up call. Now salaries are not being paid. This by reply they have proved. Yes, it is correct. Now, my lord, next paragraph. There is no doubt that the emails have been written to employees. Now, lordship, kindly see. But the intent of this is to improve the lordship got it 89. There is no doubt. There is no doubt that emails have been written to employees. But the intent to do this is to improve the attitude towards business.
Which paragraph you were reading?
At page 89. Paragraph thereafter, madam. At page 89, paragraph thereafter. There is no doubt, lordship got it. There is no doubt that emails have been written to employees, but the intent of this is to improve the attitude toward business. In 2010, so and so, Fiji's top line was 246 crores and EBITDA was 100 crores, while Akash Institute top line was 120 crores. An institute dominating the result and providing great education to students must also do great business, isn't it? Now, if your lordship now, this is the reply they have given. This is a reply given by the Fiji. Now, if you see our question number 5 in page 85, see page 85, question number 5. Now, these articles, my lord will kindly note down, these articles which we have published is on the basis of the emails which was given to the employees. It's a fact. And on various sources. Now, if you see, compared to this at 89, if you see at 85, see our query on query number 4. Query number 4, did the company hold back employee salaries to give them a wake-up call to work harder? That is what they replied. Number 5, has the management written email to employee justifying the reason behind holding back employee salaries? That your lordship will find in 89. Now kindly see second paragraph, kindly see at 85. I just forgot to read the second paragraph of we have written them prior to publication of this publication of this article. We have gathered information regarding the company and its management sending mails to his employee stating that the salaries were not paid in an attempt to give them a wake-up call to work harder amid financial trouble and rising competition. Now their reply, I have read, my lord. This is a reply which they have given to us. So what is the wrong in those articles which have been published by us? So the learned trial court, my lord, I have great respect, my lord. I go learned trial, I know we have got no respect. But the injunction, with temporary injunction, I understand, a mandatory injunction was passed to the effect to take down those articles, my lord. Now, my lord will kindly see page 90, kindly be seen, page 90 of their reply. We will send pointwise reply by tomorrow noon as our CEO and core team are busy in meeting with the managing partner. So this particular reply, I have been told that we never received this reply. We have never received this reply. That's what instruction of my client. We never received any reply from them. So 12th of March was the first article that was published. And this is the article which we published. And this article is based on the information which is given on the basis of the emails which are written on the first. So we verified. We verified. Reply has been also given by them, and this reply matches with our query that has been sought for by them to them. And detailed reply, they said it will come, it never came to us, they will reply. My lord, the articles which was published, your lordship will kindly now go back to the plaint, because I am just correlating, this is the article number 1. Now, if your lordship sees, goes back to the suit at page 43, my lord. If you see, this is article which I read, that is paragraph 15, article 1, 12 March 2024, we will lordship find at page 93. This which I read, first article. First article. Now, my lord will kindly see at page 44, this is the second article, article 2 and 3, that is 14th of March 2024. Now, second article number 2, my lord, if your lordship looks into article number 2, this is at page 102. My lord will kindly note down, article number 2 is at page 102. 102.
Yes.
This has been published on 14th of March 2024.
Where the date is mentioned?
I'm sorry, my lord.
Where the date is mentioned?
Date is lordship will see. At 111. 111 at page 111, 14/3/2024 at 111 on the top. Lordship got it? 2024-3/14.
14/3/2024.
Yes, this is the second article which has been published. Now kindly see presently wrong Fitzy founders salary. Lordship got it? Presently wrong Fitzy founder salary is not a right. Email not legally sound, says expert. So all these, Mala, I'll read these articles. When it was published, an opinion was taken from the legal experts. Opinion. So normally an opinion is taken. What do you want to say on this? Salary has been withheld. What is your opinion on that? So they went on taking opinions from different experts. So that they said this also amount to defamation. This is what they are saying. An opinion has been sought for from different particular personalities. If your lordship kindly see on the first paragraph, Money Control spoke to legal professionals and human resources specialists to understand whether the company performance management strategy is appropriate and if it could stand up to legal scrutiny. Salary is not matter of right. Test preparation, coaching from Fiji founder and managing director Dinesh Kumar Goel told employees in an email earlier this month. Now, my lord will kindly look into it. This article number 2, which they have published, which we have published, is only after the reply which we have received from them. Reply, your lordship has noted down. 12th of March 2024, we received the reply at 2:38. And this is admitted position by them. My lord will kindly see it is admitted by them. After receiving the reply, and we waited more reply which they have not submitted to us, 102, after that we have asked the expert. Kindly see, my lord, salary is not matter of right. test preparation coaching firm so and so, Dinesh Kumar Goel told employee in the email earlier this month. Now, if you kindly turn to page 103, please turn to 103, my lord. Right or not? Now, money control 103, second paragraph. Money control spoke to legal professionals and human resources specialized on whether companies' performance management strategy are appropriate and what recourse employee have to challenge FITSI decision. Right or wrong? That was the first question that was put. Rituparna Chakraborty, co-founder of staffing firm Team Lease Services, said that there are often times when business leaders have to make tough decisions. However, in any case, employers cannot suspend staff salaries as long as they are employed by the company. So this is the comment and opinion of a particular an individual. So where is the question of this article, my lord? We are asking an opinion and comment. Then each and every case there will be defamation, my lord. Now kindly see at page 104. Next paragraph, next page 104. 104. See at 104, second paragraph. T. Sundar Ramanathan, advocates and record and co-founder of Sarvada Legal, mentioned that contrary to the company's belief, employees are entitled to their salaries because everyone is working for compensation. So this is another, my lord, opinion of a lawyer. Now, if you see at page 105, kindly see at 105, Ajit Kumar, partner at Trial Law and Advocacy Record, Supreme Court of India, said that such large-scale withholding of salary is effective an issue with the company's governance. This is another opinion. Now, if you see at page 106, according to Team Lead Chakraborty, there are only a few scenarios where an employee can suspend salaries for employees. Until there is a gross misconduct or somebody has run away with money, you have to pay salary as long as person is employed, said Chakraborty. Now, if your lordship kindly see the next, after two money controls query, the company responded saying that it was an attempt at giving employees a wake-up call because they were becoming overconfident and entering into a comfort zone on the back of FITSI success. Now, at page 107, my lord, the company then also said that delay in salaries are due to hold up in submitting the required information by some of its employees, which is required in the ongoing appraisal process. Ajit Kumar told Money Control that while the employment contract might mention that a part of salary is linked to performance parameters, even under fixed aspect of pay cannot be withheld. So these are all comments and opinion which has been taken. This is article number 2, which is being published. Now here, article 3, my lord, the argument which they advance, article 3 is in Hindi, which has not been annexed. And what is that article 3? What is that article 3, my lord? What will make a difference to the court, my lord? And it is number 1, it is the body of the suit. It is in the body of my FAO. Now kindly see what says, my lord, in Hindi. Paragraph 18, my lord, page 44. Article number 3, your lordship will kindly note down it is Hindi, which is not a part of this document. My lord will kindly see 18. While plaintiff were not able to recover from the consequence of this article, defendants came out with 2 more articles. The plaintiff was shocked at this deliberate targeting conducted by defendant across their platform on 14th of March 2024. The first of these 2 articles was published on the morning of 14 March 2024 at 10:42 a.m. titled, "Presently wrong, FITSI founder salary is not a right, email not legally sound," says expert. That article 2 already I have at page 112, your lordship has seen that. 112, which I have read. Now this is the Hindi. Available at so and so holds employee salaries for second month in a row, so and second one of 2 article published on 14 January at so and so, titled FITSI. My lord, this is Hindi. मैं सैलरी मांगने गलत है, फाउंडर ने ऐसे दिया जवाब, कर्मचारी को दिल डाल गया,
दहल गया
डल गया, थैंक यू, डल गया. आई एम नॉट सो एक्सपर्ट, सो आई एम ट्राइंग. मैं सैलरी मांगने वालों को खैर नहीं. So this is, my lord, it is all related to not paying the salary on time. So how materially it makes a difference? Because the foundation of this article number 1, that's what I am submitting before your lordship. And I'll tell your lordship, this matter, a bit of background is this. This matter was moved, appeal was filed on 6/5/2024. It was filed on 6/5/2024. Now, 9/5/2024, your lordship will kindly note a few dates. I'm just going out of track of this, the article 2 and 3, I'll come. On 6/5/2024, my lord will kindly see one thing. Injunction order was passed on 19/4/2024. Lordship will kindly note down 19/4/2024, ex parte injunction order was passed. 9/4/2024, 6/5/2024, we filed the appeal, this present appeal, and that was numbered, appeal was numbered on 9/5/2024. And on 13/5/2024, my lord, FA was moved and appeal was admitted. And records were called for. Your lordship will kindly note down, records were called for that order of 13/5/2024. Now, my lord, I was not the counsel, my lord, at a relevant time. Somebody was the counsel. My learned friend was there and my learned friend assisted. But somehow, my lord, that pressed for the stay, but there was no objection saying the records should be called for. FAO doesn't consist of all the documents. Doesn't consist. Court said, what we'll do it, we'll fix the matter on 12/6/2024, after a month. Now, there was no interim order, that was, stay was not granted. And the records to be called for. I don't understand, with great respect, I am saying. This is a civil just senior division walking distance from here. Record doesn't come until 12/6/2024. We had some doubt that why records may come or may not come. What we done, entire the volume, entire documents, we submitted before the court, before the hearing takes place. It was placed before the court. These are the documents. Please hear here. It is a part of record. All these documents were submitted before the court. These documents, which documents? The list of, my lord will kind of, this list was submitted before the court because the documents, the records were not before the court. Even the records didn't came up before the court. That's why what we done before the moving the matter.
From where the records were called for?
Records were called for. They want to look into it. The records.
From where?
From the trial court. From here, civil just senior division. From here, from Guwahati itself. But this order was passed on 13/5/2024. FAO, that day it was moved and it was admitted. The court said, no, we will not pass any order now, interim order. They let the records be before the court and matter was taken up on 12/6/2024. Even on 9/5/2024, records were called for, the record didn't came. I could have very well understood it is coming from Dibrugarh, it is coming from other place. It is a walking distance from here. Record doesn't come. I don't know what is the reason. I will not say also what is the reason behind. My lord, these documents, before moving it, I placed all the documents before the court. These documents, which my learned friend said that these documents were important part of the FAO. Yes, certain documents, whether, well, I'll show before this court whether these are material documents to adjudicate, even in spite we file these documents. All the documents were before the court. The matter was taken up by the court. My learned friend was on caveat. He appeared and thereafter this stay was granted. On 12/6/2024, stay was granted. Against that, they went to the apex court. They went to the apex court. I think the grounds they have mentioned that why it has been, they went to the Supreme Court because all the documents, suppression of this document, and even there was a stay which was granted by this court. But greatest respect, my lord, the Supreme Court said, let it go, be taken by the learned court below for the High Court. Didn't interfere. Maybe the word dismissal is not there, but didn't interfere it. Because it was at the interlocutory stage. And it was sent back. So as the matter has come up before this court, my learned friend thereafter has come and filed an applicable modification variation of the order. Now your lordship is hearing the entire matter. So this matter, this was placed, it is a part of this, the record. And after that, the matter was heard. Now your lordship today, you are hearing the entire matter. The entire matter, your lordship is going to examine now the legality and validity of the injunction, ex parte injunction order that has been passed by the learned trial court. To what extent? Is this really the order is arbitrary? Is the order is so perverse that your lordship in the appellate court is going to interfere in? That's the issue before this court. And those articles which has been published, whether it was so urgent in nature that without giving a notice, my lord, an injunction has been passed. Kindly see, my lord, 12 is the first publication, 14 is the second publication, third publication is 18th of March 2024. And there is a fourth article. Fourth article. First, second, third. First is on 12, second and third is on 14, and last article is on 18th of March 2024. Now we are on the third article now. If your lordship kindly see at page 45, there's a indeed. This was not translated in this article and was not been annexed. And this is in the body of the plaint. It's the body of the plaint which is before this on report. And ultimately, the article 1, salary being not paid, wake up call, all this is related. Nothing new of these articles. One is Hindi version, one is in English version. But they said that if you have not done it, this was not brought notice to the court. Otherwise they want to say no stay would have been granted. So this is number 3, my lord. Now, if your lordship kindly see at page 45, article number, I read article number 2, my lord, before your lordship. These are all the opinions and comments of different personalities. And 3 is regarding about the Hindi version. Now, last at page 45, article 4, lordship will kindly see paragraph 19. For 18th of March 2024. Your lordship will find this at page 112.
112.
112. This is the court article which is published on 18th of March 2024. 18th of March 2024. This your lordship will find 18th of March at page 118. Kindly note down the date, my lord, at page 118. Last 2024 3/18. Lordship got it. Yes. Now kindly see what is this publication. My lord, I'll tell your lordship, this is publication is based on the reproduced on the basis of newspaper. I'll show on that. Fiji's slam for an belittling student who quit institute and got 99.99 in G mains. Disgusting. Now, my lord will kindly see. First point kindly see. Fiji advertisement published on the front page of a national newspaper claimed that the ex-student could have secured 100 NTA score in G mains 2024 and not 99.99 if she remained with them and not shifted to an evil institute from Kota with a history of suicide. Fitzy has been receiving massive backlash over the weekend after it published an advertisement in a national newspaper mocking a student who quit the coaching institute and opted for another. In the end, Fitzy revealed the student's academic performance, her school details, and her photo. At a time when coaching institutes have been advised even by the government to be sensitive while dealing with students in the wake of multiple suicide, advertisement came across shameful and disgusting, social media users said. The matter was brought to the light when Indian Revenue Service officer Katyani Sanjay Bhatia shared a photo to the ad on X. Is a tutor, my lord. X is a tutor. A new law in advertisement Fitzy. You are posting a picture of a child saying she performed badly because she left your institute. I have blurred the picture because I don't believe in this disgusting way of claiming your superiority by belittling a girl child, she wrote. So this has been written, an opinion of a particularly, this is a comment, interaction, which we have asked, this is what we have, and this is enter this, I will show it, my lord. This publication is reproduced on the basis of a newspaper, some other new Republic, Mint, which they published earlier. This we have reproduced in these articles. Now, my lord will kindly see at page 113. In a separate post, she added, we talk about parents putting pressure on kids for IITG, but what about this manner of advertising, where you shame a student for not performing and claiming superiority by claiming that she should have performed had seen been in your institute shameful. 114. The advertisement published on the front page of Daily claimed ex-students could have secured a 100 NTS score in G Mains 2024 and not 99.99 if she remained with them and not shifted to an evil institute from Kota with a history of suicide. The G Institute was also slammed for crystallizing his competent evil. So they said if they would have been our institute, 100 marks. If you would have been other institute, 90.9 marks. This is a comment which is given. And this will reproduce on the basis of other newspapers. My lord will kindly now see at page 115. 115. This is a tutor of that Katyani Sanjay Bhatia. Kindly see. This is follow tutor, a new law in advertisement at Fitzy. You are posting the picture of a child saying that she performed badly because she left your institute. I have blurred the picture because I don't believe in disgusting way of claiming her superiority by belittling a girl child. Now, kindly, the IRS officer also sought to bring the matter attention on the Ministry of Education and the Ministry Women and Child Development. Since the institution used history of suicides as a parameter to attract potential students and customers, they are claiming their superiority by talking about the institute with a history of suicides. Shameful. Suicides in Kota are an issue that concern us all. Have ever petty competition, but claiming in this manner is cheap. Bhatia wrote tagging the official account of ministries and Union Minister Smriti Irani. Such advertising malpractice need to be checked. No institute has a right to shame students to claim its superiority. Several others shared an opinion. Now, if you see at 117, that is also Katyani Sanjay Bhatia, my lord. Now, if you see at page 118, 118. India has to get out of this ultra competition exam, pressure on children and young adults. This is one area where I would not learn from East Asia, but instead learn from Finland, which has a superb state-funded education system, and that serves every child without such competitive insanity. Bamu wrote on X, intense pressure at a young age all too often destroy talent and create zombified adults. It is a rat race to extinction. Intense competition is for companies serving a market and for sport, not for children education. Fitzy holds employee salaries for second row, make them work harder. Now, this is what my lord opinion which has been published. Now, if you see all this, these articles, Lordship will see at page 126. see at page 126, my lord. It starts from all this article at page 120, 120, first 120. These articles in Business Today. Lordship, kindly look. This is reproduced in article number 4. This is Business Today, article 4. Now, my lord will see article 4. His lordship can mark it page 120 to 125. All different the news house. This is Business Today. It start from page 120 to 125. If your lordship kindly see, shameful new law in ads, IRS officer blasts GZ for posting picture for whose code law. Now, Katyani Sanjay Bhatia, Deputy Commissioner, took strong action to advertisement. No institute has a right to same student to come as a new law in so and so. You are posting the picture as she is performed badly because she left your institute. So these are all reproduced. Now, if you see at page 121, 122, 123, now kindly see at page 125. This published on, my lord, 125. Kindly see, this is published on 17 March 2024 at page 125 by Business, by Business Today. It is not that we only have published. There are other business which were reproduced there. And the court said, take down all these articles. Now 125, published on 17, Lordship will kindly mark 17 March 2024 at 5:30. This is published by Business Today. Now there, I don't know whether there is a case against them, I don't know. And we published, my lord will kindly see, we published on 18/3/2024. That's article number 4. After they published prior, then we have reproduced all this in article 4. Now kindly see at page 126. 126. This is Republic. At page 126, Republic. Now, my lord will kindly see 126 is published by Republic.
120?
Page 126.
126, yes.
Kindly Republic. Kindly see the date. Updated March 15th of March 2024. Kindly see, my lord, decoding the Fitzy Fioso is the brick and mortar coaching model crumbling. This is published by Republic. If you see at page 127, kindly see 127. 127. Step 1, click here. The Fitzy salary delays is one layer of a larger underlying issue in the brick and mortar coaching model for entrance exam. In the internal mail to employees, Delhi headquarters coaching is delayed salaries for 50% employee, citing various reasons for the institute since 1992 has become synonymous with preparation for joint entrance exam for entering prestigious engineering institute, including the Indian Institute. So whatever we publish, that's correct. See kindly, my lord. 133, kindly see now. These are all goes on at page 133. 133. Now 133, my lord, by Republic. 133, bottom, the affected employees. What are their rights? A company can defer salary payment for 2 months, but only in case of overbearing losses, after which is mandatory for them to pay salaries, even if that means they need to sell asset for the same according to so and so a corporate law at Noida-based employment agency. So these are the all comments. Now, if you see, last at page 141, kindly see at page 141. This is by Mint, the Wall Street Journal. The Mint. This is by Mint. Sorry, it's not Wall Street, it's a Mint. It is by Mint. At 141. Lordship got it? Now kindly see the date. 13 February 2024. Lordship got it? So this is 1 month prior to the article which we have published on 12th of March. This is 13th of February 2024. Kindly mark, my lord, it is 13th of February 2024. And our first publication was 12th of March 2024. Now, kindly see what they have written. Bottom, my lord. New Delhi, FITZI Limited has suspended salary payment citing cash flow issue. 5 company executives said at the time the test preparation firm is squeezed by rising losers and competition. So this is what, my lord, the articles which has been published, it is based on the newspaper. And this main information which we received. And this publication is by Mint is on 13th of February 2024. And what is the topic, my lord? Topic is the withholding of the salaries. This is not we said. Republic, Mint, and one of the Mint, Republic, Business Today. So now, my lord, will kindly look into these are the articles which has been published. Now, what is about the prayer they have sought for? Prayer they have sought for in the suit.
At page number?
Page number 57. 57 is the what is this? Suit. What is a prayer in the suit, my lord? We'll kindly see at page 57. 57. Pass a decree of permanent injunction, thereby restraining the defendant, their agent, representative, assigns, or any other person related to them for posting, publishing, or circulating any defamatory article posted against the plaintiff herein. B. Pass a decree of permanent injunction, thereby restraining the defendant, their agent, representative, assigns, or any other person related to them for posting, publishing, or circulating any post that amounts to disparagement of plaintiff services. Pass a decree of mandatory injunction in favor of the plaintiff and against all the circulating the impugn article against the plaintiff herein. And E. Pass a decree of damages on account of defamation of plaintiff, disparagement of plaintiff services in favor of the plaintiff and against the defendant to the extent of 5 crores. So this is the prayer which they have made in the suit. Along with the suit, my lord, they file an application under Order 39, Rule 1 and 2, which your lordship will find on the next page at page 60. Now, kindly see the prayer at page 78. Is the prayer. Pass an order of interim injunction including ex parte in favor of the plaintiff, thereby restraining the defendants, their agent, representative, assigns, or any other person related to them till the pendency of the present proceeding from posting, publishing, or circulating any defamatory article post against the plaintiff. B. Pass a order of interim injunction including ex parte, thereby restraining the defendant, the agent, representative, assigns, or any other person related to them till the pendency of the present proceeding from posting, publishing, or circulating any post that amount to disparagement of plaintiff services. Pass an order of interim injunction including ex parte in favor of the plaintiff and against all the defendant, thereby direct the defendants to immediately take down the impugn articles or any other similar articles or any other post, write up or material concerning or in relation to these impugn articles. So all these prayers has been allowed. And the prayer in the suit is only in regard to compensation has been paid, like amounting the whole suit. Now, what made them, my lord will kindly see the dates. 12th of March, 14th of March, 18th of March. These are the date of publication. Now, they doesn't give any reply. Reply was on 12 of March later on. Even they said on their reply that we'll intimate father, they kept quiet. The reason behind is at page 119. Kindly see. Page C, page 119. My lord. Now, my lord will kindly note down the date at page 119.
Yes.
This is 25th of March 2024. This is one of Director of Digital. Your Lordship, I read that, then your Lordship will know what purpose is that. We are writing to address some concern that have arisen following some recent media reports regarding FITZI particular article published by Money Control, which has caused considerable apprehension among our partners and the student community in Guwahati. The article in question alleges FITZI bankruptcy and failure to pay its employees' salaries, a claim that has understandably sparked widespread concern and speculation. While we were on the verge of finalizing our agreement to open a FITZI franchisee in Guwahati for the upcoming academic session, this unexpected development has prompted our partners to postpone our plans pending further clarification from FITZI. The negative public publicity generated by the article has led to inquiries and doubts among our stakeholders, including aspiring students, regarding FITZI future prospect in Guwahati. We are witnessing discussion and trolling on social media platforms such as X, which further exaggerates the situation and undermines confidence in the brand. Given the seriousness of this allegation and the potential impact on our business venture, we are seeking assurance from FITZI regarding the accuracy of the information presented in the media reports. We believe that obtaining confirmation from FITZI and reaching as a resolution on this matter are crucial steps before proceeding with our franchisee proposal. On this, once the situation is clarified, any concern I address, we remain open to revisiting the possibility of establishing a FITZI franchise in Guwahati. However, until we receive reassurance from FITZI, issue is resolved, we find it prudent to refrain from further pursuing our plan. We appreciate your understanding and cooperation in the manner and look forward to your prompt response and guidance and how best to proceed in light of this development. So this digital wants to have a franchisee with this FITZI. Now, when this particular news cropped up, then they became aware. And they said, this is what is troubling us. Please let us know. What is this? What is going on? My lord will kindly see, this is 25th of March 2024. But there are other newspapers which I am showing much before the publication. One is 13th of February 2024 about FITZI. Now, this is on 25th of March 2024. They doesn't do anything. They doesn't file a suit. They file a suit, your lordship will kindly note down, on 19th of April 2024. Suit has been filed. And their explanation that why the suit was delayed, because there was Bihu holidays. Bihu holidays starts.
There was?
Bihu holidays. Bihu holidays starts on 2nd week of April. From 25th up to 2nd week of April, the trial courts were open. At that time, you did not move the trial court for a suit. Only on 19th of April, you have filed a suit. You waited for such a long. And 1 month you waited, and the learned trial court, with great respect, my lord, on day one, has granted all the relief. And I will read that order, my lord, is ex parte. It's total in ex parte order, my lord.
No, is there any bar in granting the order on the same day?
No, ex parte order can be granted.
Then?
On what situation ex parte order has been granted? My lord, we'll have to see my lord, absolutely there is no bar. Whether these type of cases, my lord, where the journalists, medias, all this, whether this type of case, an ex parte, to what extent the court can look into it. Freedom of speech. I'll show one judgment of the Supreme Court latest 2024, my lord, in this type of cases. I'm not saying, my lord, injunction cannot be granted ex parte. That is, you have to see the veracity of those articles. My lord, my respectful submission before this honorable court was the plaintiff has filed this suit.
No, court has to consider only the documents placed before it.
Right.
It cannot gather the
Not at all. No,
information from the
I fully
other
agree.
platforms.
I fully agree with your lordship. I fully agree with your lordship. Whether these type of cases, my lord, an ex parte injunction allowing the whole prayer. I told on the very beginning, my lord, there can be a restraining order and not to publish. But letting down, take down the articles with great respect, I have some reservation on it, my lord. That I have reserved, I'll show it, my lord. I'll show it by a judgment of an apex court, how it has been dealt in this type of case. Is on exactly on the point, bang on this point, my lord. Well, I agreed with your lordship. I also know ex parte injunction can be granted. Whether these type of cases, while dealing the matter by the court, whether the injunction which is granted, and kindly see the finding of the learned trial court, my lord. What is the finding? Now we take your lordship to the finding of the learned trial court. How an injunction was looked into by the trial court and how injunction was granted. Kindly see at page 81, my lord. 18.
Yes.
19.
It starts from 82.
Yes.
No, 81, yes.
81.
81, yes.
81.
Yes.
The instant miscase has been registered a petition so and so filed by the plaintiff petitioner praying for grant of ad interim injunction, restraining the opposite party, the agent, representative assigned any other person related them till the pendency of the present proceeding from posting, publishing, or circulating any post that amount to disparagement of plaintiff services, and as well immediate take down the impugned articles or any other similar articles, any other post, write up or material concerning on relation to this impugned article against the petitioner. Now, my lord will kindly, my learned friend has also read, I think, at page 83, kindly see the operative portion at paragraph 10. Paragraph 10. Upon hearing and perusal of the petition, as well as relevant documents filed by the petitioner, it transpired that there were a series of publications in money control, .com portal, other social media, including Facebook, LinkedIn, Twitter, about the petitioner institute company regarding withholding of employee salary and touching upon the petitioner bankruptcy as alleged by the petitioner. It also appears that tuition cum coaching institute, namely Digital, who were intending to open a Fiji franchisee in Guwahati for upcoming academic session, sought clarification on 25/3/2024 from the petitioner company about the said development, thereby causing harm to the reputation of the petitioner. It appears that there is a prima facie case to be heard. Decide if the OP defendant continue to publishing in a moneycontrol.com portal and other social media, including Facebook, so and so, about the petitioner institute company. Petitioner intend to continue or repeat the LS publication. There is a prospect of such immediate further pressing injury to the petitioner. Thus, the balance of convenience lies in favor of the petitioner plaintiff. Further, in the event of petitioner plaintiff is not protected, in the interim as paid for, petitioner plaintiff will suffer from irreparable loss and injury. On consideration of the facts and circumstances and the above triple test, I am of the considered opinion. Relief claimed by the petitioner is urgent in nature, and the purpose of injunction is likely to be defeated by delay. As such, in the interim, the opposite defendant, the agent, representative assigns, or any other person related to them are restrained from posting, publishing, or circulating any post that amount to disparagement of petitioner plaintiff service, as well as immediately take down the impugned article dated 12th of March 2024, 14th of March, 18th of March, and any other similar articles or any other post write-up or in material concerning or in relation to this impugned article against the petitioner till next day is fixed. So, my lord, the 3 points which they have raised for granting of an interim injunction, all has been granted. And more so, taking down all those posts has also been granted. That means removing those particular posts. So if the court decide after 3 months, well, then there is no point of again those particular posts again to be restored. I understand, my lord. I fully agree with your lordship. An ex parte injunction can be granted. Whereas these type of cases, how it has been dealt.
No, can it be said that no prima facie case is made out?
I'm sorry.
Can it be said that no prima
No,
facie
either
case
way,
is made
prima
out?
facie case can be made out.
Then
Prima facie case, making a prima facie case and balance of convenience and irreparable loss and injury, that doesn't mean that all, my lord, then your lordship will look into, I'll show one judgment of the Supreme Court, how it has been dealt, these type of cases. But a prima facie case, in other case, yes, we understand. But this type of case, the court has to be more cautious.
maybe, but no separate parameters have been laid down.
I'm sorry, my lord.
No,
Supreme Court.
yes, yes.
I'll show it. It is the same parameters. I'll show it. What is the case about? Straight away, I'll take to the judgment, my lord. Because I think the view of this court, your lordship, I'm very happy that I know your lordship's mind that whether in ex parte number 1, whether an ex parte injunction can be granted. Yes, ex parte injunction can be granted. Now your lordship's view is prima facie case. Prima facie case, why this type of case? Yes, there is a prima facie case. If there is a prima facie case, then why an injunction cannot be granted? If I'm not wrong, that's what your view, my lord.
No, the relief granted is discretionary, and the court, having been satisfied with the submission and the documents placed on record, granted the injunction.
No, then I will say, what is that prima facie case? The court has granted, prima facie they were satisfied. Whether the court prima facie could have been satisfied in this case. That is why I'm before
So
this court.
according to you, there is no prima facie case.
There is a prima facie case, but balance of convenience should have been looked into it by the court.
The court has discussed it in the impugn order.
No, that discussion we have put to challenge. That's a perverse. That discussion. No finding on it. Where is the finding, my lord? Let's see where is the finding. Let's see where is the finding on it, my lord. Prima facie case at page 83. Let's see where is the finding. How it is prima facie case, well, how it is the finding. Let's see, my lord. Upon hearing at page 83, I'm troubling your lordship again. Upon hearing and perusal of the petition, as well as relevant document filed by the petitioner, it transpired there was a series of publication in Money Control, other social media, so and so, about the petitioner institute company regarding withholding of employee salary, touching about the petitioner bankruptcy as alleged by the petitioner. I am putting a stop here itself, my lord. Now, my lord, have seen the documents which is before this court, my lord. These documents which I have read the articles because it was before the learned trial court about this article. Basing on the article, then based on this document. Based on this document, the learned court has what finding the learned trial court has said that we have perused the documents. These are the documents which have been perused, and I find that this is as alleged by the petitioner. Kindly see, touching upon the petitioner as alleged by the petitioner. It also appears that tuition come coaching is namely so and so, intending to open a Fiji franchise Guwahati upcoming. Since sought clarification petitioner company about the said development, thereby causing harm to reputation of the petition. It appears that there is a prima facie case to be heard. Yes, there may be a prima facie case to be heard, but these are the allegations.
No, what else is required to make out a prima facie case?
My lord, you are asking a injunction under Order 39 Rule 1-2, and also you are seeking an interim mandatory injunction. Mandatory injunction is on a higher pedestal than a prima facie case.
Where it is stated?
I will state. What
No,
is
is
that?
it there in the CPC?
Yes. CPC, I'll state. CP under section 39 of the Specific Relief Act is a mandatory injunction. Mandatory injunction under section 39 of the Specific Relief Act.
Hmm.
But here is a case where they have sought from primary case as well. Kindly see the prayer which they have sought for.
Hmm.
Prayer which they have sought is not only Order 39 Rule 1 and also granting a mandatory injunction.
Hmm.
So when ex parte, my lord, taking down is, my lord, granting in a positive manner that take down is more than a prima facie case. My lord, restraining further publication, yes, I have understood. Order 39 Rule 1 and 2, restraining. But in a positive manner, take down is a mandatory injunction which they have prayed for, and an interim mandatory injunction has been granted by the court. So it is more than a prima facie case the court has to look into while taking down. That is my submission before your lordship. I would not have trouble by filing an appeal under Order 43. That is the perversity in the order. My lord, restraining, I am clear to your lordship. Restraining Order 39 Rule 1 and 2 is a restraining order, temporary injunction. We pray for a, in the suit, a permanent injunction, then only we can pray for a temporary injunction. Now in the suit, we pray for a mandatory injunction. Now mandatory injunction is a higher pedestal. The court, now suppose I am in possession, suit is pending, I have been thrown out. While pending pending proceeding. Now I come up before a court, say that I want a mandatory injunction, believe during the proceeding I have been thrown out. Unless I can be restored back because I am in possession of that. It's a separate issue altogether. Because I am in possession of that. But here is a case where one step further, the learned trial court has exercised its jurisdiction under section 39 for granting an ad interim injunction in a form of a mandatory injunction. Because their prayer, kindly see the prayer, my lord. Once again, I'm troubling your lordship. See the prayer at page 57. See page 57. See page 57. Pass a decree of permanent injunction, thereby restraining the defendants, their agent, representative assigned, any other person related to them for posting, publishing, or circulating any defamatory article, post. Pass a decree permanent injunction, thereby restraining defendants, their agent, representative assigned, or any other person for posting, publishing, and post them. Pass a decree of mandatory injunction in favor of plaintiff and against all the circulating paper against the plaintiff. So now, here everything has been done. In a form of mandatory injunction, in a positive manner, it has been allowed. Now, my lord, now I will say your lordship was asking me, what is that mandatory injunction? Whether one is a difference with great respect, a difference under Order 39, Rule 1 and 2, so far as injunction is concerned, restraining is a restraining order. But when a mandatory injunction is granted, it is like a form of a positive order. It is more than a prima facie case. So the learned court should have gone one step ahead, saying, where is that more than a prima facie case? It has not been said anywhere. My lord, what I am saying, that I could have said on the very opening, that there can be restraining order, prima facie to the extent.
Okay, now you saw the judgments.
Yes, now my lord will kindly, now kindly see the Bloomberg judgment. Then I will show what is mandatory injunction. See at page 6, my lord.
Who is judgment?
At page 2024 SEC online SC 426.
Okay.
Lordship
Yes.
got it, my lord?
Yes, yes.
This is 1, 2, 3 judges. 3 judges. Now kindly see. Now kindly see at 6, my lord. Paragraph 6. I'll show that judgment. In addition to this oft-repeated test, there are also additional factors which must weigh the courts while granting an ex parte ad interim injunction. Some of these factors were elucidated by 3 judge bench of this court in Morgan Stanley Mutual Fund of so and so. The following terms: 36. As a principle, ex parte injunction could be granted only under exceptional circumstances. The factors we should weigh while the court in the grant of ex parte injunction are whether irreparable or serious mischief will ensue to the plaintiff, whether a refusal of ex parte injunction would involve greater injustice than grant of it would involve. Now, C is important. The court will also consider the time at which the plaintiff first had notice of the act, complained so that making of improper order against a party in his absence is prevented. Now, my lord will kindly note down, pausing for a moment, at C, 12th of March 2024, 14th of March 2024, and 18/3/2024, and query by Digital was 25th of March 2024. And this suit was filed on 19/4/2024. So what it says, the court will also consider time at which the plaintiff first had notice of the act. So notice of the act was on 12th March 2024. Complaint so that making of improper order against a party in his absence is prevented. Now, kindly D, the court will consider whether the plaintiff has acquiesced for some time and in circumstances it will not grant ex parte injunction. The court would expect a party applying for ex parte injunction to show utmost good faith in making the application. Now, if you see at now, even if granted, ex parte injunction would be for a limited period. General principle like prima facie case, balance of irreparable loss would also be considered by the court. 7. Significantly, in suit concerning defamation, now Lordship got it, my lord, by media platform and or journalists, an additional consideration of balancing the fundamental right of to free speech with the right to reputation and privacy must be borne in mind. The constitutional mandate of protecting journalists' expression cannot be understated, and the court must treat cautiously while granting pre-trial interim injunction. The standard to be followed may be borrowed from decision in Bonnet versus so and so. This standard crystallized the Bonnet standard laid down by the Court of Appeal has acquired the status of a common law principle for grant of interim injunction in defamation suit. The Court of Appeal in so and so. No, they have quoted them. Now, paragraph 9 kindly see, they have quoted this to English judgment. Paragraph 9. In essence, the grant of a pre-trial injunction against the publication of an article may have severe ramification on the right to freedom of speech of the author and the public right to know. An injunction, particularly ex parte, should not be granted without establishing that the content sought to be restricted is malicious or palpably false. These two are important, which, my lord, while deciding the injunction order, this was not being looked into by the court. Now, my lord, granting interim injunction before the trial commences in a cavalier manner, resulting in the stifling of public debate. Got it, my lord? In other words, court should not grant ex parte injunction except in exceptional cases where the defense advanced by the respondent would undoubtedly fail at trial. In all other cases, injunction against the publication of material should be granted only after a full-fledged trial is conducted or in exceptional cases after the respondent is given a chance to make their submission. Where is that, my lord? So I think, my lord, this is a fit case, my lord, where your lordship, that is why, my lord, the appeal was filed. You know, I have, with great respect to learned trial court, I have not found that this is malicious or palpably false.
No, whether at that stage a death finding can be arrived at by the learned trial court.
Which finding? The finding.
Yes,
But-
that finding, that malicious finding,
But you have to see other factors. What ramification will be there?
that can be arrived at only after trial.
No, that is what the court said. Kindly see, my lord. Thereafter, granting interim injunction. Kindly see, after palpably false, granting interim injunction before the trial commences in a cavalier manner results in the stifling of public debate. My lord, in other words, my lord, court should not grant ex parte injunction except in exceptional case where the defense advanced by the respondent would undoubtedly fail a trial. In all other cases, injunction against the publication of material should be granted only after a full-fledged trial is conducted or in exceptional case after a respondent is given a chance to make the submission. Where is that chance which was given to us? Now kindly see 10. Increasingly, across various jurisdictions, the concept of slap suit has been recognized either by statute or by courts. The term slap stands for strategic litigation against public participation and is an umbrella term used to refer to litigation predominantly initiated by entities that wield immense economic power against members of media or civil society to prevent the public from knowing about or participating in important affairs in the public interest. We must be cognizant of the realities of prolonged trials. The grant of an interim injunction before the trial commences often acts as a death sentence in the material sought to be published. Well, Lordship got it, well before the allegation have been proven. While granting an interim injunction in defamation suits, the potential of using prolonged litigation to prevent free speech and public participation must also be kept in mind by courts. 11. The order of a trial does not discuss even cursory the primary strength of the plaintiff case, nor does it deal with the balance of convenience or the irreparable hardship that is caused. Trial judge needed to have analyzed why such an ex parte injunction was essentially after setting out the factual basis and the contention made by the respondent made before a trial judge. Trial judge merely stated in para 7 and 8 that court has gone through the records available as on date and noticed certain precedents where an ad interim injunction was granted without even curiously dwelling on the merits of the plaint. The ad interim injunction granted by the trial court just amount to unreasoned censorship which cannot be countenanced. That's our case, my lord. By going through only documents, on the document which is submitted, prima facie, some reasoning should have been there. There is no reasoning as such. Kindly see 12. Undoubtedly, the grant of an interim injunction is an exercise of discretionary power, and the appellate court, in this case, High Court will usually not interfere with the grant of interim relief. However, in the line of precedent, this court has held appellate court must interfere with the grant of interim relief if the discretion has been exercised arbitrarily, capriciously, perversely, or where the court has ignored settled principle of law regulating the grant or refusal of interlocutory injunction. The grant of an ex parte interim injunction by way of an unreasoned order definitely falls within the above formulation, necessitating interference by the High Court. This being a case of an injunction granted in defamation proceeding against a media platform, the impact of the injunction on the constitutionally protected right of freedom of speech further warranted intervention. In view of the above, High Court ought to have, in our view, of at least prima facie assessed whether the test for grant of an injunction was duly established after an evaluation of fact. Same error which has been committed by a trial judge had been perpetuated by a single judge of the High Court. Merely recording that a prima facie case exists, that a balance of convenience is in favor of grant of injunction, and that an irreparable injury would be caused, would not amount to an application of mind or to the facts of the case. The threefold test cannot merely to be recorded as a mantra without looking into the facts on the basis of which injunction has been sought. In the absence of such a consideration, either by the trial judge or by the High Court, we have no option but to set aside both the order of the trial judge and the of the learned single High Court. Later we do so accordingly. Since the proceeding are now listed before the trial judge, we direct that it be open to respondent to renew the application for injunction, which the trial judge has passed fresh order after hearing the parties and bearing in mind observations which are contained in the above segment of the judgment order. All the rights and contention of the parties are kept open in this regard. In the event appellants seek to contest the application for injunction, they shall file the reply before the trial judge before the next date of listing. It is clarified. Above segment of judgment order may not be considered a comment on merit of the present case. Purpose of the above segment is to provide the broad parameters to be kept in mind while hearing the application for interim injunction. The appeal is accordingly disposed of in the above terms and conditions. So this being a defamation suit, my lord, the same, it can be set aside and can be sent back to the trial court for deciding the issue. And if your lordship feels that no further restraining order can be passed not to publish, then of course your lordship can do it. But taking down and doing everything, allowing it, my lord, that's what the court said. Merely prima facie case, looking at a document, that is not enough. In this type of defamatory, this type of suit. That's my humble submission so far as the judgment is concerned, my. So lordship query to this, to the particular, the whether an ex parte injunction can be granted. Yes, I do agree that ex parte injunction can be granted. But in this type of cases, whether ex parte injunction could have been granted in this situation in the present case. I think it is a similar case which I have cited. It is also defamation suit. The Supreme Court said it has to be acted more carefully in deciding a defamation suit. That's what I understand, my lord, from the judgment of the episode. Your lordship has to look into the judgment and interpret in what manner, whether this fits in your case or not. But I humbly make up, my prayer is that yes, this fits into our case. Now, next point. Now, my lord have seen that. I don't want to show again. Prayer part, my lord, they have asked for a mandatory injunction. Whether taking down, it is more than a prima facie case they have to set. Because that is not only Order 39 Rule 1 and 2. Now, my lord will kindly see now. See para 7, my lord. Para 7.
Para 7 of?
Para 7 of the judgment. 2019, 16 SCC, page 678.
What is the citation?
2019, 16 SCC, page 678. Paragraph 7. The learned counsel appearing for the respondent argued before us and attempted to support the judgment. He cited the judgment of Dorab so and so. Paragraph 16 of judgment is set out here. The relief of interlocutory mandatory injunction are thus granted generally to preserve or restore the status quo of the last non-contested status which preceded the pending controversy until the final hearing, which full relief may be granted, or to compel the undoing of those acts which have been illegally done, or the restoration of that which was wrongfully taken from the party complaining. But since the granting of such an injunction to a party who fails or would fail to establish right at the trial, which may cause greater injustice or irreparable harm to the party against whom it was granted, or alternatively, not granting of it to a party who succeeds or would succeeded may equally cause great injustice or irreparable harm, courts have evolved certain guidelines. Generally stated, these guidelines are plaintiff has a strong case for trial, that is itself be a higher standard than a prima facie case that is normally required for a prohibitory injunction. It is necessary to prevent irreparable or serious injury which normally cannot be compensated in terms of money. The balance of convenience is in favor of the one seeking such relief. This judgment also makes it clear that when a mandatory injunction is granted at the interim stage, much more than a mere prima facie case has to be made out. None of the aforesaid provision of the judgment have either been averted to or aided by the impugned judgment. We therefore set aside the impugned judgment, restore the judgment of the courts below. So there are three prayers basically which they have made. Permanent injunction 2 and 1 is mandatory injunction. Now in the suit and in the main under Order 39 Rule 1 and 2, they also prayed that it should be taken down. They should take down those particular articles, which is a form of positive order that has been passed. So it is more than a prima facie case. You are taking down those articles. Today also I am saying, my lord, restraining an article, restraining for further publishing and taking down those articles. Taking down this article, you have entered to main suit, and in a form of a positive order, you are passing an order. It is more than a prima facie case. So where is those observations? Number one, my lord, the order that has been passed by the trial court is only, my lord, an allegation, and it is only those three principles have been laid down and based on those documents. Now the Supreme Court in that Bloomberg judgment categorically stated the defamation suit, you have to be more careful. That's what I have understood from their judgment. So your lordship has read the judgment, how the apex court has dealt insofar defamation suit is concerned. It is not like other suits. Freedom of speech, freedom of press, all these are involved. Media is involved. So all this, we have, my lord, that has to be looked into by the court. Mere stating all these three triple tests regarding prima facie balance of irreparable loss, that by making that there's three tests, that doesn't amount that I have gone through it, documents have looked into it, so I am passing an injunction order. A respectful submission, I defer, my lord. That's what illegality, arbitrariness, and perversity in the order. That was I have come for exercising of power under order 43-1. So these two judgments, now my lord, now that I will, the argument which is advanced by, so my prayer is that your lordship can set aside the judgment of the royal trial court. Let it be remanded back to the learned trial court. Learned trial court will hear it. I will file an objection, and thereafter, my lord, the matter can be taken up for hearing the injunction application. Suit that will take time because the question of evidence is there. This order can be set aside, sent back to the learned trial court. Learned trial court will give an opportunity to file an objection, and if a time-bound period, and that can be heard. And in the meantime, if your lordship wants some protection should be given, then further they will not publish. It is not why I am before this court. They cannot ask for taking down those articles. That's what I am on by taking down those articles. Take down those articles. What remains to be decided? What remains to be decided? It will be restored after 4 months. It will be restored after 5 months. It will be restored after a year. Those articles. It will have no value on those articles. He is allowing the whole suit. Whether it was permissible to take down is like a positive form of an order the learned trial court has passed in a form of mandatory injunction. What remains is only go back there. My lord, it has all been taken down. All these articles to take down the article. That is why they are saying we file an application under order 39 rule 2A and you have not taken down those articles. Now, my lord, I'll say 2 points which has been raised. Is number one, while FO was filed by us, now appeal was filed against that order. Now against that order, my lord, there is an application which has been filed by them under order 39 rule 2A. And there is an order which injunction order was passed. Now the submission of the other side is that when the injunction order was passed and it was in operation, and there is a contempt which has been filed under order 39 rule 2A, you should have complied, then you will be heard in this matter. You cannot be heard in this matter unless you don't comply with those directions passed by the learned trial court. For that reason, we have filed a contempt. To that extent, my learned friend has showed one judgment of the Supreme Court, prestige judgment. My lord, I think that judgment is before this court. Kindly see what is their judgment about. My learned friend has read only paragraph 24. What is the actual judgment? That is 2007, 8 SCC, page 449. It's completely on a different context. 2007, 8 SCC, 449. My lord, will kindly, I am thankful to my learned friend who has supplied a copy. 2007, he was relying on the judgment. 2007, 8 SCC 449. Lordship, got
Yes.
it, my lord. If your lordship kindly see paragraph 4, the facts of the case. Each case has to be understood what in context, what is the facts of the case, and what is the proposition of law that has been laid down. Kindly see 4. The Lordship got it. 4, paragraph 4.
Yes.
The appellant herein is a private limited company engaged in manufacturing bulk chokes and fittings. Factory of the appellant is situated at so and so. In 1992, the appellant obtained a loan of rupees 85 lakh from State Bank of India Commercial Bank, Radha Place so and so. Respondent herein. Company mortgaged its land and building with the respondent bank. Accordingly to the appellant till 2001, business of the appellant was comparatively good and it had no problem in depositing the interest accrued toward credit facility. In or about 2001-2002, or because of heavy slump in the market due to arrival of cheaper Chinese product, the appellant suffered huge losses and could not deposit the interest amount with the respondent bank. Respondent bank therefore issued a notice on 16/10/2004 under subsection 2 of section 13 of the Securitization and Reconstruction of Financial Assets Enforcement of Security Interest Act, herein refers to an act, alleging herein the appellant failed to pay some of rupees so and so. So basically, my lord, it was a loan was taken. He borrowed loan from the bank. It was not repaid. So they invoked the surfacing. They invoked the surfacing and they said, you have to pay this amount, a sum of rupees so and so. Now, my lord will kindly see at paragraph 8. Paragraph 8, interim order that has been passed by the High Court. Right? Now see at paragraph 8. It appears that because they put to challenge 13.2, my lord will kindly see this. Then when the surfacing 19 to 13.2 notice was issued, my lord, that was put to challenge. Now, my lord will kindly see 8. It appears that a mention was made to the court on 28/4/2005 and the court ordered registry to list the matter as notified. Stay of disposition was however granted. On 6/5/2005, notice was issued and interim relief was granted on certain terms and conditions which will refer to an appropriate state. Affidavits and further affidavits were filed by the court. Director registry to place the matter for final hearing. Accordingly, the matter has been placed before us. Now, if your lordship looks into at paragraph 22, this is what has been considered. This has been considered by the High Court. From the above order, Supreme Court, no? This order. From the above order, it is clear notice was issued to the other side and stay granted earlier was ordered to continue on the appellant depositing a sum of rupees 20 lakh per month in this court. It was also made clear that first of such payments should be made by 6/6/2005 and subsequent payments by 6th of each succeeding month. A default clause was also introduced in the order. If such payment would not be made, stay would stand vacated. It is admitted fact order has not been complied with and no payment as per the order has been made by the appellant's company to the respondent bank. The said fact has also been reflected in the order of the court passed on so and so, where it was stated, it is recorded the stay is transgressed by reason of the admitted non-compliance with the order dated 6/5/2005. Now 24 has been relied by my learned friend. An order passed by a competent court, interim or final, has to be obeyed without any reservation. If such order is disobeyed or not complied with, the court may refuse the party violating such order to hear him or to merits. We are not unmindful of the situation that refusal to hear a party to the proceeding on merit is a drastic step and such a serious penalty should not be imposed on him except in grave and extraordinary situation. But sometimes such an action is needed in larger interest of justice when a party obtaining interim relief intentionally and deliberately flouts such order by not abiding by the terms and conditions on which a relief is granted by the court in his favor. Now kindly see paragraph 26. See paragraph 26. That however does not mean that each and every case in which a party has violated an interim order has no right to be heard at all. So what my learned friend said that you complied, then it will be heard. Nor will be the court refuse to hear him in all circumstances. Normal rule is that an application by a party will not be entertained until he has purged himself of the contempt. There are, however, certain exception to this rule. One of such exception is the party may appeal with a view to setting aside the order on which the alleged contempt is founded. A person against whom contempt is alleged must be heard in support of submission that in regard to the meaning and intendment of the order which is said to be disobeyed, his action did not constitute a breach of it. So para 24, all you have to read para 88 along with para 22 and paragraph 26. By reading 24, it will have no sense. Now, my lord, what my learned friend, now I'll give a reply to this, whether without complying an appeal can be filed. Otherwise, your lordship knows in each and every case, when an interim order is passed, that means we have to comply, then only an appeal can be filed. See, this is 1995, supplementary 4 SCC page 465. 1995 supplementary 4 SCC page 465. Paragraph 4 kindly be looked into it, my lord. Paragraph 4. Paragraph 4. Before the High Court, appellant urged that before any contempt proceeding, what you got it, could be initiated, it was necessarily appropriate for the division bench to examine the prayer for stay, or else the appeal itself might become infectious. This did not commend itself to High Court, which sought to proceed with the contempt first. We are afraid the course adopted by the High Court does not commend itself as proper. If without considering the prayer for a stay, obedience to the single judge order was insisted upon at the pain of committal for contempt, appellants may find as to how happened the very purpose of appeal and the prayer for interlocutory stay infructuous. It is true that a mere filing on appeal and application of stay do not by themselves absolve the appellant from obeying the order under appeal, and that any compliance with the learned single judge order would be subject to the final result of the appeal. But then the changes brought about in the interim in the obedience of the order under appeal might themselves be a cause and source of prejudice. Wherever the order whose disobedience is complained about is appeal against and stay of his operation is pending before the court, it will be appropriate to take up for consideration their prayer for stay either earlier or at least simultaneously with the complaint for contempt, to keep the prayer for stay standby and to insist upon proceeding with the complaint for contempt might in many conceivable cases as here cause serious prejudice. This is view taken in so and so. 5. In the present case, under the threat of proceeding of contempt, appellant had to comply with the order of learned single judge, notwithstanding the pendency of the appeal and the application for stay. The petitioner are confronted with the position whether the stay application virtually rendered infructuous by steps that had been taken on threat of contempt. We accordingly direct that all further proceeding in the contempt proceeding be stayed. It will be appropriate for the High Court to take up the dispose of the application for stay without reference to development in the interim, namely that the respondent had to obey the order of the learned single judge under pain of proceeding of contempt, depending upon the outcome of the appellant application for stay. The further question whether or not the reinstatement should be reversed would arrive, appeal is disposed accordingly. So it is very clear that application under Order 39 Rule 2A that it will not be heard unless we don't comply. It's absolutely, my lord, is incorrect. That is what the apex court has said. So that contempt proceeding was kept in abeyance by the Supreme Court. So that has been. So this is, my lord, two judgment which has been placed before the court. Now I will show the documents. They said there is some non-compliance that in the FAO was filed. We didn't annex all the documents. That's what they said.
No,
There
that
was
was
sufficient-
only in respect of that IA.
Yes,
Is it relevant in case of the appeal?
yes. They said there is
That was only in respect of this
That's not-
recalling the interim
That's right.
order.
That's right.
Mhm.
But they said that is not.
Now, if we are
You are
hearing the
hearing-
appeal.
Your lordship is hearing the entire appeal. That's
Then-
not.
Milord, my submission.
I mean,
Yes.
My submission, as I said at the outset, I'm sorry, my lord, to interrupt my lord. My submission is that the appeal has been heard. There are preliminary objections to its maintainability at the threshold. The first is that there is material concealment and suppression of material documents. That's one. Two, there is also non-compliance. These are two preliminary grounds. If your lordship finds them sustainable, then the appeal is dismissed on that ground. It's not a question because the appeal goes on that ground alone. And that is what the what I'd shown to your lordships on the last date, and which is what
Yes.
the judge. And then on merits, then without prejudice to those submissions, then yes, on merits, if at all, if the need arises. So they would continue to be relevant whether, my lords, it is in the case of the IA as well as, my lords, in the case of on merits as well, both.
But I will just give a reply. Your lordship is not hearing the IA. Your lordship is disposing the entire appeal.
Yes, yes.
And your lordship is looking to veracity of the injunction order that has been passed.
Mm.
Whether that injunction order which is passed, Learned Court, at all your lordship will interfere that order or not. That to that extent your lordship will looking into it.
Mm.
Not only other aspect of the matter. Because we are on appeal against the order of injunction. Your lordship has to look only the injunction order. Whether the injunction order, whether it needs an interference or not, or whether it doesn't need any interference. There are two grounds, my lord. Whether it needs interference or it doesn't need interference. Either my appeal is dismissed or my lady is set aside, appeal is allowed and goes back to learned trial court. I think that's what your lordship is hearing the entire case. I think this stage, your lordship is right. I also see that this is not so relevant now at this stage. The articles were before the learned trial court. Those articles were looked into it. The learned trial court has found that yes, I find that a prima facie there is a case to go for a trial. Balance of convenience is also in the favor, is in favor. So I do hereby grant an injunction restraining not to publish or also to take down all those articles. So, lordship, this finding, there was some sort of finding. Whether I was aggrieved by that finding, and I showed the judgment of this, or whether your lordship, those judgment by the apex court in 2024, that can be taken into consideration in our case. Bloomberg judgment.
So your part is over now.
Yes.
Okay.
So my submission before your lordship is that this needs an interference by this court because it is arbitrary and perverse, this particular judge.
Okay,
the order
okay.
that has been passed by trial court. It can be set aside and it can be sent before the learned trial court. That's my respectful submission. Set back. And again, a chance can be given to us and your lordship want the further restraining order can want not to publish. That's a requirement. But I am repeating again, taking down those articles, my lord. that is
Okay,
totally-
okay.
That's my submission.
Okay.
I'm deeply obliged, my lord.
Okay. Yes, Mr. Hazarika, are you ready to argue the matter today?
My lord, I can do it because it will take about half an hour, 45 minutes. I can do it on Monday at 2 p.m.
Monday?
2 p.m.
Monday?
Yes, my lord.
Okay.
2 p.m. my lord.
Okay. So,
I
both the
just-
parties are duly represented. Part in part, list the matter on Monday for further hearing.
2 p.m. minutes.
2 p.m. If necessary, if I think the reply is necessary, then I'll give a reply.
2 p.m.
No, he will first argue this matter. After finishing his argument, if necessary, I'll give a reply, my lord.
Okay.
At 2 p.m. At
So,
2 p.m. 2 p.m. itself.
Yes, Mr. Hazarika?
I'm fine, my lord.
2 p.m. Okay. Okay.
I'm ready.
2 p.m.
I'm deeply obliged, my lord.
Grateful.
Really? What?
Item number 26. Item number 26.
None appears for the appellant on call. Recessal is the matter after 1 week.
Item 50. Item 50.
I am for the sole respondent. This is basically a second appeal. I have filed, I as a plaintiff filed a suit for rejectment on the ground of Urban Rent Control Act. Suit
But
was decreed.
where is the appellant? So sort that then. Sort that. None appears for the appellant on call. However, Mr. Goswami, learned counsel for the
He
respondent.
was waiting for, he was also waiting with me, Lordship. Lordship, may fix any date, Lordship.
Okay, list the matter in next week. In the event of subsequent non-appearance, appropriate orders shall follow.
Item number 27 for orders.
Nice, Lordship. CRP Lordship, one of the performer defendant respondent expired Lordship. So I filed an application for substitution of the names of the legal heirs, Lordship, but that was filed beyond 90 days. So there is a delay of 178 days, Lordship. Due to Corona and misplacing of the files, Lordship, the delay was caused. I have explained the delay, Lordship. Para 5 to 10 Lordship. 5 to 13 Lordship. Sorry, Lord.
Who is for the respondents?
Well, time for respondent number 1, woman 2, my Lordship.
Respondent number 2.
Respondents have not filed any objection. And the deceased was a performer defendant.
But the other respondents are absent. Should we hear the matter in their absence?
Against all notices have been served.
Pardon?
Against all the respondents, notices have been served.
Sir, but today the other respondents are absent.
They have not filed any objection. Even my
No,
last
maybe,
friend has
maybe.
also not filed any objection, affidavit in opposition.
Let us fix a sort date.
Okay.
Sort date. Heard Mr. Espiro, learned counsel for the petitioner, and Mr. Your good name, please.
R. Ali.
R. Ali, learned counsel for the respondent number 2. None appears for the other respondents. List the matter in the next week. In the absence of, in the case of subsequent non-appearance of the respondents, other respondents, appropriate orders shall follow.
28.
Wait, your Lordship. Lordship, in this case, I have instruction that the sole respondent expired, my lord. But the problem is that, my lord, I don't have the details of these legal heirs and the date of his expiry, my lord, to file the appropriate application, my lord.
Now, what is your submission?
My lord, my submission is that I need the details from them, my lord. As per order 22, my lord.
Okay. Pardon me, sir, your good name?
P. Bora.
Learned counsel for the appellant, and Mr.
A Burua.
A. Burwa, learned counsel for the
Sole
respondent. Sole respondent. Learned counsel for the appellant submits that all the appellants herein suffered demise, and as such, he submits that a direction may be issued to the respondents to furnish the details
Yes, my lord.
of the appellants,
Respondent,
respondents,
sole respondent.
Where is accordingly allowed. Learned counsel is directed to furnish the details of the respondents to the learned counsel for the appellant. This is the matter after 2012. 15 matter. Can you take a step within 2 weeks?
Kindly after 3 weeks, because we have to again contact the respondent, we also don't have.
3 weeks.
3 weeks after.
Okay, 3 weeks.
Pleasure.
29.
May I please, your lordship? Your lordship, service has been completed, lordship, and LCR has also been received.
LCR received.
Yes, lordship. A date may be fixed,
Okay.
lordship, for here.
Third miss, your good name?
B. Hajorika.
Learned counsel for the appellant and Mr.
W. Raman on behalf of GP Bhomik.
GP Bhomik, learned counsel for all the respondents.
Yes, Lord.
It is submitted at the bar, the service completed and the LCR has also been received and the matter is ready for hearing. Accordingly, it is provided that rest is the matter for hearing in usual course.
Sorry, lordship.
Lordship, may kindly fix any date after Puja vacation, Lordship, if possible.
Okay.
On 5th November. Item 30.
11.
None appears for the appellant on call. How, Mr.
Yes, Chaudhary.
S.
Chaudhary.
Chaudhary, learned counsel for the respondent present. List the matter after 2 weeks. In the event of subsequent, it is ready for hearing.
Can we fix for admission? My orders is order columns came today, madam. The matter may fix for admission.
It is not admitted. You are for all the respondents.
I'm sole respondent. I'm sole respondent, madam.
Sole respondent, only one respondent. Okay. Recessal is the matter for admission hearing. In the event of subsequent non-appearance, appropriate order shall follow.
31.
Well, the appeal is ready for hearing. Appeal is ready for hearing. LCR is received.
Ready for hearing. Both the parties are duly represented by their engaged counsel. It is submitted that the matter is ready for hearing, as the LCR has also been received. Accordingly, it is provided that recessal is the matter for hearing.
The respondent is about 80 years old.
Pardon?
The respondent is about 80 years old.
80 years.
Filed the suit in there 1993.
Okay, we'll fix a sorted then. Copy.
On 29 October.
Obliged.
Obliged.
Item number 32.
None appears for the parties on call. Recessal is a matter after 2 weeks. In the event of subsequent non-appearance, appropriate orders shall follow.
33.
Yes.
Item,
Lordship,
sorry, Lordship, item 32.
Lordship, you order.
33.
After that, Lordship, may I come? Item 32.
Lordship, 2 weeks time may be allowed, Lordship.
Pardon?
2 weeks time may be allowed, 2 weeks time for filing objection, Your Lordship.
You are for respondent number 1
1
and
and
2.
2, Lordship, yes.
Lordship, only last occasion also they sought for an adjournment.
Actually, Lordship,
On the first two
respondent
occasions, they never appeared. Third day, they appeared and sought for an adjournment. Today also, they are seeking for an
Lordship,
adjournment.
actually, respondent number 1 is hospitalized, so for taking instruction, we need some time, Lordship, so I'm praying for 2 weeks time.
Heard Mr. A. Deka, learned counsel for the applicant, and Ms. A. Dutta. What is your name?
A Deka.
No, your name.
My M does. Lordship.
M does, learned counsel for the respondent number 1 and 2. Ms. Das submits that although 2 weeks time was granted to the appellant, granted to the respondent, yet objection could not be filed on account of illness of the respondent number 1, and therefore she prays for granting further 2 weeks time. So we'll grant you 1 week.
God bless, Lordship.
Accordingly, it is pair is allowed. The learned counsel is granted 1 week time to file objection. This is the matter after 1 week.
Interim order was it?
Interim order partial result continue.
34.
My lord, on the last 25/7, 2023, this court was directed to the appellant, respondent to file their objection regarding the IA number 2281/2023. On that IA, we had filed for direction to pay 50% from the awarded amount. So till today, they have not, 1 year is over. They have not filed any objection.
Pardon?
We have filed lordship. Objection. Everything objection, we have filed.
I have not received any copy and there is no.
We have filed the objection, lordship.
No.
Last one, there is no one I received.
Honest. May I please, your lordship. We have filed the objection, lordship.
My lord, we have not received any copy.
Okay. Maybe the case.
Email
lordship,
office record there.
We have filed the objection, lordship. We had filed the objection, lordship.
But as per office record, I have seen the record, there is no remark of filing their objection.
Anyways, lordship, the LCR has come. They are paying for 50%, deposit of 50%. But lordship, in this case, lordship, no provision of the Employees Compensation Act has been provided, followed, lordship, while giving the judgment. There is a delay of 4 years, lordship. The statutory notice under section 21(3) has not been given. No record, no evidence was allowed to be adduced by the respondent, lordship.
Now, my lord, kindly see my written objections. There are sufficient times given to the opposite parties to adduce their evidence, and they have appeared before the commissioner office and they have submitted their WH. And as per section 30, within 3 months, that case has to be disposed of. And my lord, as per section 30 of EC Act, without submitting any deposit of certificate, an appeal cannot be live. So they have not submitted any certificate of deposit.
Now, lordship, if I may, lordship, section 21(3), section 21, lordship, for admission of an application under this Employees Compensation Act, lordship, the accident had happened in Manipur and they filed the application in Lakhimpur, lordship, in a different state, in a different district, lordship. Section 21, lordship, of the Employees Compensation Act provided that no matter shall be processed before or by a commissioner other than the commissioner having jurisdiction over the area in which the accident took place without giving.
This appeal is filed against a money decree,
Lordship.
right?
Lordship.
This appeal is filed against a money decree.
Yes, lordship.
So what is the principle? You have to deposit the security.
Yes, my lord.
Security is 50%. You deposit the amount.
Yes.
Lordship, that I understand, Lordship, but where he, as per our appeal, Lordship, the entire proceeding is
No,
misconstrued.
we will hear you.
Lordship,
We will hear you.
Lordship.
So you comply with the order.
Yes, my lord. Yes, so my husband is died. This is the case of 2018. So I have a children. So how can I survive? And they are arguing here is there is no jurisdiction. My lord, section 21 of EC Act, there is clearly mentions venue of proceeding and transfer. There is mentions that the accident took place, which resulted the injury. The employer, or in case of the death, the dependents claiming their compensation, the employer has this regards office. Provided date, no matter shall be proceed before a commissioner or other claim commissioner having jurisdiction over the in which the accident took place, without having noticed the matter prescribes. My lord, there is another provision that's that the claimant is the residing of the jurisdiction of the not looking for. So she cannot go to the Manipur to claim in such compensation.
Lordship, there is no need for going to Manipur. There is what has been prescribed here is just statutory notice, Lordship. That the notice has to be given to the commissioner at Manipur, Lordship. That a case has been filed before the commissioner in Lakhimpur, and that has to be complied with, Lordship. It's a statutory provision, Lordship.
First of all, going to the merits of the case, my lord, maybe please dispose of the IA 2281. Yes, we are requesting to this honorable court to give direction to pay this 50% that we can survive, my lord.
Lordship, other than that, Lordship, we had also filed an IA 3601 of 22. It was for the stay of the judgment, Lordship.
But still,
that is also pending, Lordship.
You deposit 50% of the amount. Heard, Mr. Your good name?
BR does, my lord.
Learned counsel for the applicant and Mr.
K. Das, Lordship.
K. Das,
Lordship,
learned
my
counsel
humble
for the.
submission is that the withdrawal may be prohibited till the disposal of the case.
No, my lord. My lord.
Lordship, the LCR.
No. You deposit the amount. We will see it later on.
Yes, my
Learned counsel for the respondent. Opposite party. This interlocutory application is prepared by applicant Srimati Mami Kurmi. For issuing direction to the appellant, instruct respondent to deposit 50% of the awarded amount in respect of MFA number 111 of 2023 against the present applicant. Learned counsel for the applicant submits that. In EC case number 01 of 2022, where is that order?
My lord, page number 7. This is typical letter. And page number 9 is the actual.
The commissioner under Employees Compensation Act 1923, North Lakhimpur, has directed the respondent to pay a sum of rupees 11,14,424. And against the said award, the appellant has preferred an appeal before this court, which is registered as MFA number 111 of 2022. The said MFA has already been admitted for hearing. And that the present applicant is the widow. And as such, and she has no source of income and has also burden of looking after her minor children, and as such, it is prayed that the appellant may be directed to deposit 50% of the awarded amount. That is
It could be my.
sum of rupees 5,57,212 before the registry of this court. Whereas the learned counsel for the appellant, public respondent, has opposed the petition on various grounds. However, considering the facts and circumstances on the record and also considering the submission of learned advocates of both the parties, it is provided that the appellant shall deposit 50% of the awarded amount, that is a sum of rupees 5,57,212 before the registry of this court within a period of 2 weeks.
4 weeks may be granted, Lordship.
4 weeks,
Lordship, 4 weeks.
3 weeks, within a period of 3 weeks from today.
Lordship, LCR has been received. The date will be fixed for hearing, Lordship. LCR has already been received.
In terms of above, this IA is that's disposed of. In IA, no, in main appeal, you take down. Both the parties are represented by the Indian counsel. LCR has also been received, and it is submitted at the bar that the matter is ready for hearing. And accordingly, it is provided that recessal is the matter for hearing in usual course.
My lord, liberty may be granted to withdraw the deposited amount.
Lordship, a bond may be signed because Lordship, we have enough grounds, Lordship, to have a success in this appeal, Lordship, actually.
My lord, there are.
Liberty is, however, liberty is granted to the applicant to withdraw the amount on executing a bond.
Just fine.
35.
Thank you, Your Lordship. It's a vacating petition I have filed and pleadings has been completed in the IA, my lord. But it will take time, my lord. May I pray fixing this matter on 16, my lord?
When?
16 of this month, my lord.
16.
There is an urgency also. It's take time, my lord.
As grateful, no, as agreed by learned advocates of both the parties, recessal is the matter on 60.
36.
This IA is for what purpose?
For vacating the interim order passed by this honorable court in the main writ petition, my lord. And that IA, my lord, pleadings had been completed. Some time is required for hearing, my lord. That's why I'm praying for fixing it because there's no time, my lord.
No, the main matter is ready for hearing.
No, my lord, IA is ready for hearing, my lord, because in the IA, I'm appearing on behalf of only one respondent, my lord. And there will be two private respondents, my lord. I appeared on behalf of one respondent, my lord. And
So
that
service completed
service has been completed, my lord.
in the main appeal.
Main petition service.
No, main petition.
Yes, my lord.
Complete.
Completed, my
Then we can hear the entire matter.
lord. That can be also, my lord.
Hmm?
On 16, my lord.
On that day, an endeavor will be made to hear and dispose of the entire matter.
Hello.
36.
None appears for the petitioner on call. Recessal is the matter after 1 week.
37.
My please, your lordship. Lordship, the service is complete as the court has showing that the respondent has filed wakalatnama yesterday, lordship.
Yesterday.
Yesterday. They have filed.
Where are they?
They are not appearing, but they have filed the e-court shows, lordship.
Pardon me, sir.
MH Ali.
Your name?
MH Ali. MH Ali.
M.H. Ali, learned counsel for the petitioner. None appears for the respondent.
Lordship, on the last occasion.
However, learned counsel for the petitioner submits that yesterday the counsel for the respondent has filed wakalatnama. But It is not available here.
Lordship, they have filed yesterday.
Yesterday.
Which maybe not updated.
Or SSL is the matter after 1 week.
On the last occasion, the honorable court has passed an order that interim relief will be considered only after due service of the respondent lordship. Therefore, interim relief may be given.
Let him appear.
Lordship,
Let the other side appear.
Next date is fixed on 9th of September, lordship.
19,
9th of September.
9th of September.
On next Monday, lordship.
Okay, next week. Next week.
38.
Your Lordship, I am for the respondent number 5. I for the vacating the order dated 13/10/2023, Lordship.
The other side is absent.
Lordship.
Your good name, please.
KM Saikia. KM Saikia.
Heard Miss K.M. Soikia, learned counsel for the applicant. This application is preferred by the applicant. Dr. Lokhiram Nursery
Yes.
for vacation, stroke modification, stroke alteration, stroke cancellation of the order dated 13/10/2023 passed by this court in WPC number 6044 of 2023. It is to be noted here that by order dated 13/10/2023, this court was pleased to direct the parties to maintain status quo as regard the service of the petitioner till returnable date.
Lordship, I have joined on this post on 1/5/2023, and I have already continually drawing my salary, Lordship.
In the main petition, have you filed affidavit?
Lordship, yes, Lordship.
When?
Wait. See, on November, Lordship, 2023.
November 23.
30/11/2023.
It is not available on the record. Okay, okay, it is present. But the other side is absent.
Yes, Lordship. Lordship, they have not challenging the advertisement, Lordship. After when the list come out, then they come before this honorable court, Lordship.
Let a copy of the petition be served upon the respondents. List the matter after 2 weeks. The main petition I will take down.
Wait.
In the main petition, I go for respondent.
Yes,
Number
Lordship.
5.
Yes, Lordship.
Petitioner is absent.
Yes.
None appears for the petitioner on call. However, Ms. Suikya, learned counsel for the respondent number 5 present. And you are for
Respondent 1 and 2, Lordship.
your good name?
They are having that.
Learned counsel for the respondent number 1 and 2. And you? Pardon?
Council of God University. Respondent number 3.
3. Okay, respondent number 3. List the matter after 1 week. No, 2 weeks. 2 weeks. After 2 weeks.
39.
In the event of subsequent non-appearance, appropriate orders shall follow.
Lordship, in this matter, Directorate of Higher Education has forwarded the matter to the Lordship government, Lordship. So 2 weeks time may be granted so that.
In this contempt petition,
Yes. Contempt, Lordship.
heard Mr.
Concern.
Sarma, learned counsel for the petitioner, and also heard Mr. So-and-so, learned counsel for the respondent. Mr. So-and-so, learned counsel for the respondent, price for granting 2 weeks time.
2 weeks.
2 weeks time. Here is accordingly allowed. Recess is the matter after 2 weeks.
Item 40.
May I please, madam? The IA number 2402 of 2024 has been filed. This is by the appellant claimants. My lord, for sending back the LCR for a limited period. What happened, my lord, against the award passed by MSCT tribunal, my lord, the claimants have preferred an appeal. Appeal was admitted by this honorable court and LCR was called. The
Appeal was
LCR
disposal.
No, appeal is pending. LCR has been received by this honorable court.
Yes.
Thereafter, respondent has deposited the awarded amount before the tribunal. Now, without the LCR, which is pending here, they are not releasing my amount. Right? Therefore,
Where it is pending?
it is before MSCT 2, Kamrup Metro.
Kamrup.
Yes.
So for that purpose, a record is not required to be sent back.
So earlier, I have moved similar applications, and that is being
No,
sent. to-
in that case, they can open one supplementary file, and
That
in
is-
that supplementary file, they can release the amount.
That is not available with them. We have approached them. They said they without
No,
the
no,
LCR.
they can start a supplementary record.
But I have intimated, yet your lordship has, at the time of mentioning the matter, your lordship has indicated.
Yes.
I have confirmed with them that without the LCR, it is not possible on their part to release the amount. Because that has to be written and signed by the parties.
No, then again, we have to call for the record.
The record, no. Lordship may send it for a limited period of time, and that has to be returned by them. That was
That is not the procedure. When the record is not available, usually a supplementary record is started.
my lord, that I have intimated them, that your lordship has already indicated me on the last occasion.
Okay, we will issue direction then.
Direction to that.
Heard Mr. Bhatta says a learned counsel for the applicant. This interlocutory application is preferred for issuing direction. Now, for sending back the LCR of MSC case number 365 of 2021 to the Court of Learned Member MSCT.
Number 2.
Number 2, Kamrup M. Guwahati. For the purpose of receiving the awarded amount deposited by the opposite party number 1 and 2, pursuant to judgment and order dated 18/5/2023, passed by the Learned Motor MSCT number 2, Kamrup M, in MSC case number 365 of 2021. Who preferred the appeal? You.
I.
Mr. Bhattacharya submits that against the judgment and award dated 18/5/2023, the applicant had preferred an appeal before this court, which is registered as MSC
Appeal number 314,
MSC Appeal number 314 of
23
2023
for enhancement.
for enhancement of the awarded amount. And in the end, after admitting the appeal, this court was pleased to call for the record from the learned member MSCT, and the same has been received. And subsequent thereto, the
Appeal number 1
respondents
and 2.
number
1 and 2.
1 and 2 had deposited the awarded amount before the learned tribunal, but the said amount has not been released by the learned member MSCT number 2 Kamrup M on account of non-availability of the MSC case number 365 of 2021.
Record
And therefore, this application is preferred for sending back the LCR of MSC case number 365 of 2021. Further, having heard the submission of learned counsel for the applicant and also considering the facts and circumstances on the record, the learned member MSCT number 2 Kamrup M is directed to start a supplementary file in respect of MSC case number 365 of 2021 and to release the awarded amount to the applicant within a period of 1 week from the date of receipt of a certified copy of this order. In terms of this IASN's disposal.
much of that.
Much of
May I please your lordships? Sorry,
Sorry, order has already been passed.
Just called the lordship, none
Sorry.
that may be.
There is sanctity of the order of the court. You cannot recall it as your own.
Matter called on 33, there are immediately these lordships. Immediately lordship, that may be.
Take a date from him.
Item 49, next week any date, my lord.
Okay.
Item 51, Lordship.
Okay, he will accommodate.
Interim will continue, lordship. Interim.
Interim, okay. You give the number to him.
Lordship.
Okay.